in the parallel meeting of the collegium that is considering candidates for the position to the Cassational Administrative Court within the Supreme Court. But we have quorum. It's more than enough. That is why we are continuing working. I'm asking to invite the candidate Borbela Yuri Sergeyevich. This is Borbela Yuri Sergeyevich, the candidate for the position of a judge to the appellate chamber of the High Anti-Corruption Court. We welcome you. Please sit down. You are present here at the special joint meeting of the HQCJ of Ukraine and the PCIe. You have the following rights: to submit motions, to provide oral or written explanations, upon the consent of the chairperson to provide your opinions, or if you have recusals, please tell do you have recusals. Please switch on the mic. I do not have recusal. Thank you. The rules of procedure is as follows. So within 5 minutes, there is a presentation of the PCIe member, your response within 5 minutes, and up to 20 minutes. The questions and answer session. We have online broadcasting at the YouTube channel, and translation is being in place. That is why we're asking you not to talk fast, and also take into consideration the necessity of interpretation. The presenter on your question is Lorna Harris. I'm sorry, Lorna Harris. Please, you have the floor.
Thank you, Mr. Chairman, and good morning. This is a complex case, and I hope you will forgive me if I take you in some detail through the complicated circumstances surrounding this candidate and some of the issues which concern us. If I could say at the beginning that running throughout the story I will tell you is the question of his relationship with his former wife, V. Borbela. There is a doubt about the genuineness of the candidate's divorce from his former wife. He declares that he and his wife had ceased to live together in 2003 and were in fact divorced in 2008. In 2008, however, the candidate, who has been a judge since 2007, borrowed $90,000 from a bank, and his wife, bearing in mind that this is the year they were divorced, agreed to act as a guarantor for her husband and provided her apartment in Sevastopol as a guarantee. The loan was used by the candidate to buy an apartment in Kiev, and the apartment was valued at approximately $256,000. The candidate, in due course, paid off this loan. However, in 2013, the candidate took another loan of $30,000 from the bank to complete the apartment in Kiev and provided a land plot belonging to him as a pledge. However, the candidate could not repay that loan, and his ex-wife repaid the debt, and in exchange donated the land plot which had been pledged to the bank to the candidate's daughter. The apartment, which had been purchased earlier, was then given by the candidate to the daughter in circumstances which I will describe later. He did not declare the Kiev apartment in 2013 when he had bought it, and in 2014 when he gave it to his daughter. In 2010, in 2014, in 2015 and 2017, there were substantial gifts made by both the candidate and his ex-wife to their daughter. They donated property in the amount of 1,921 million hryvnia, the candidate himself did, in 2014, and in 2017 his wife donated property in the sum of nearly 2 million hryvnia. In order to substantiate the source of these funds, these very substantial funds, the candidate produced an accounting certificate in Russian, which to us appears to be false, and I can give details of why we think it is not a genuine accounting certificate. It purports to show that the ex-wife of the candidate had received from a company in occupied Crimea $136,000 US. The certificate is without a date and number and uses an out-of-date address. I can tell you that it says apparently Ukraine rather than in 2017 as it would have been Russia. It follows from that that we have a reasonable doubt about the candidate's integrity. However, I would like to continue. In 2013, a panel of judges chaired by the candidate convicted 3 persons on charges of terrorism and other charges. Preventive measures were applied to the defendants. The verdict was cancelled on appeal, and the candidate says that supporters of the accused had put pressure on him, and their behaviour in court gave reason to believe that the use of preventive measures was necessary to ensure proper procedural behaviour. He says that these threats by supporters of the accused continued out of court and actually led to him donating the flat that he had in Kiev to his daughter because he felt threatened living in his house. The candidate suggested that in the Court of Appeal, some of these witnesses changed their testimony. This gives us doubt about the candidate's integrity and judgment. In 2014, the candidate had declared a parking lot in Kiev at an address. His ex-wife was, in 2014, a victim of a robbery, which she reported to the police. She told the police that her official address at that time was the address adjacent to the parking lot. This casts further doubt on the fact that the divorce from 2003 and 2008 was genuine. If I can conclude where I started, with the fictitious, as we allege, divorce. In 2017, on Facebook, we have a photograph posted of the candidate and his wife. I'm sure you can't see it from there, members of the Commission, but on the left is a happy photograph, apparently, of the candidate and his daughter, and on the top right is a photograph of the candidate and his ex-wife in a position of some intimacy, sharing a drink. Mr. Chairman, Those are the circumstances which lead the PCIe members to believe that this candidate lacks integrity and should not be further considered.
Thank you, Ms. Harris. Yuri Sergeyevich, right now you have an opportunity within 5 minutes to provide your explanations. Yes, please. It is clear, thank you. Firstly, I would like to inform that doubts were caused by completely other questions according to the information note. That is why what I've prepared for my presentation, I will not right now state that. If you will have any questions about that, I will answer these questions. And right now I would like to explain what has been informed by the honorable member of the PCIe. Firstly, everything I've heard right now, in my opinion, is related to the fact that there was a wrong translation of those explanations that I provided. Let's start from the first point. This apartment that I purchased, yes, in townhouse, in fact, it was not in Kyiv. It is 8 kilometers from Kyiv, the rural area. Then, the certificate about some 136,000 hryvnias. I do not quite understand what you are talking about. When I received questions from the PCIe about the fact that it is necessary to indicate that what my ex-wife gifted to our daughter, that my daughter has a lot of various items of such gifts, I turned to my ex-wife with a question. Is it really like that? And I read out the questions to her. I asked her whether she could confirm somehow all this. Her financial capacity, her property state, exclusively for the purposes of my participation in this competition. She agreed to do that, even though we do not communicate with her. We meet once, maximum 2 times per year, exclusively for purposes indicated, in purposes related to our daughter, at her birthdays. Dear member of the PCIe, may you please show this picture again, these pictures that you've showed. Can you please show them again? Yes. So, this photo that is to the left, this is really my ex-wife. This, at that time, we, a year before the last year, at the birthday party of our child. I was there for about 15-20 minutes. My ex-wife was there, remained there, and then we move on. This photo to the right, I ask you, members of the PCA, to look at it. Please stop. May I look at it closer? As a chairman, I'm asking you, and I draw your attention, I suggest you to to behave as reserved as you can. I'm sorry, and not to speak too loudly. I'm sorry. I'm sorry, because I'm worried, and besides, we have such a quality as stress resilience, so please show it to us. Thank you, and I'm sorry, Ken. So, the photo to the left, this is my daughter. This is first. The photo to the right, this is a completely other woman.
it is a different woman, yes, with whom I am dating. But this is a completely different woman. And this photo of my daughter, so please pay attention to this fact. I do not quite understand what is going on. So about now the fictitious nature of our divorce. I've informed the truth that actually since 2003 we've had no relations within the husband and the wife. We lived in different towns. I lived in Simferopol, where I worked in the investigative department, and she lived in Yevpatoria. Since 2004, I was transferred to Kyiv, to the main investigative division of the Ministry of Internal Affairs of Ukraine. We divorced. We would have divorced earlier, but for some reason she didn't agree for that, and to make that in simple way. In 2008, she agreed to divorce. She received my written consent. She applied to court in Yevpatoria, and we divorced. Now, with respect to this apartment, with an area of 330 square meters. In 2006, I concluded an agreement with a construction company, Kyiv Gradobud. The value of this apartment in the townhouse at that time amounted to $160,000. This amount, $250,000, this is for me the first time I hear this number, this figure. With a view to fulfilling my obligations, I sold an apartment in the city of Simferopol that I purchased it in the past, with the help of a loan as well. A copy of the agreement, of the sale and purchase agreement of this apartment, I've provided it to the members of the PCIE. So under this agreement, of construction agreement, the price of this apartment, I mean, that is close to Kyiv, was 808,000 hryvnias. I sold the apartment in Simferopol for 700,000 hryvnias. Besides, I took, due to replanning and other events, the area increased. This was exclusively because of the landscape, etc., and the area increased. And I really took a loan in the amount of $90,000 US. And I really will remind you again, we were not in marital relations, but we have a shared daughter. And we have to think about her future. And in the future, of course, we wanted to provide her with respective conditions of her life and her family's life. And I thought about myself and my wife, my ex-wife, didn't have an intention to move to Kyiv, of course, at that time. This all occurred after 2014. Due to all, in relation to all the events that all of us know very well. I have to ask you, how much time do you need to finish? I suggest, for me it is difficult to say how much time I need. I ask to you to ask me specific questions, and I will provide specific answers. Let's move on to the session of questions and answers. Dear colleagues, do you have any questions? Гладій Степан Васильович, Юрій Сергійович, for you to make it easier to answer, and let's start with the very first point, the loan that in the amount of 90,000 hryvnias in 2008, or $90,000 in 2008. What was the loan, and why did you need this money? Because this is the Ukrainian Industrial Bank. Was this related to this apartment, or was it related to the Crimea? No. What Crimea? Since 2004, I've been living in Kyiv, and I have no relation to Crimea. This loan was needed exclusively to fulfill my obligations under this agreement, under this construction agreement for this apartment in townhouse. This is what you said, that you had an agreement concluded in the amount of 808,000 hryvnias. Yes. At the beginning, this was amount, but in general, it was 1,200,000 hryvnias paid. So I see. Please tell us. You've explained that for the purchase of this apartment, you spent 10,000. This is what you indicated in the PCIe explanations to the ACPs. This was your benefit received after resignation from MIA bodies. Then you have 90,000 as a loan from Ukrprombank, and then from the sale of the apartment in Simferopol. So please tell us, this loan, under this loan was your wife as your guarantor? Yes. Did you repay this loan? Yes. So please tell us when. Until 2013, this loan, my ex-wife was paying for this loan. This was based on our agreement with her due to divorce and division of property. She undertook the obligation to repay this loan. And until 2014, inclusive, she almost repaid it. Why almost? The $5,000 were not repaid. In this year, 2013, due to banking instructions, new norms and revisions, she could not issue payments because in Crimea they stopped accepting these payments. And then I, here in Kyiv, had to take measures to repay it. I mean, I was paying the interest. There was not $5,000. Interests were about $50 every month. I will remind you that in 2013 it was 400 hryvnias per month. It was not a burden for me. But according to the schedule, repayment schedule, the loan was taken for 15 years. And based on this repayment schedule, all the payments were paid until 2022, except for interest. That's all. What can you say about the judicial decision? One of the questions, and you've prepared to this, was it related to this loan? Yes, it was related to this loan. So please tell us, in what year did you finally repay it? Final payments were paid by me this year in August and September. This happened when at my workplace, a private executor came to me and informed me that here we have such a decision. The proceedings have been opened, and I am obliged to fulfill the decision of the court. I looked through the decision of the court. At first, I intended to appeal to it because I knew nothing. Employees of the bank called me on a monthly basis where they were asking me when I will pay this $50. For me, it was a huge surprise. But then I looked and saw that it is necessary to repay it. At that time, I had an opportunity to pay it. If we exchange it into hryvnias, in terms of the remaining part of the loan and court fees and payments to the executor, this was 110,000. I had 60,000 in my savings for this year since pension was paid again, and 40,000 in August. There was a transfer. Well, there was a recalculation of judicial salary because since the beginning of the year and till August, we received the salary with a minimum, subsistence minimum, 1,600 hryvnias, and then 1,700, about this amount. And then in August, I received 40,000 hryvnias. So you repaid these funds. In what year was the right of ownership registered for this apartment? With the area of 330 square meters. In what year? In 2013. And in what year did you take a decision to give this apartment to your daughter? So the agreement, deed of gift, is dated March the 1st of 2014. So please tell us. A PCA member asked the question about why didn't you declare this apartment? I'm explaining, and I've provided these explanations. Due to the case of Vasilkiv terrorists, so-called Vasilkiv terrorists, and I've informed already, I received threats, mass riots, and other criminal proceedings were initiated with respect to them. And when I was discharged from the hospital, in a day, I was in the reanimation of the regional hospital because with the secretary prosecutor who supported the accusation, only with the help of the unit, Gryphon and Barcode units, we were taken out of the court premises. It was a very tense consideration of the case, and I was really tired, and that's why I got to the hospital. After the hospital, at the place where I lived with my daughter, the entire hall of the building was full of stickers and leaflets that here lives a judge who accused the terrorists, and the photos of this apartment were in the internet, were shown on TV. And on March the 1st, I took a decision to give this apartment since I was also under security measures, by the way. I also have additional documents to confirm this. Under these conditions, I could not go to that object, even though it was not suitable for living at that time. On the 1st of March, I took a decision. Why I'm telling you all this in such detail? Because since then, as I got back from the hospital, I saw all this. I realized that my stay together with my daughter entailed danger for my daughter, for those persons who would be there. And since then, I have not lived with my daughter according to the requirements of the declaration. Firstly, family members are persons There are the following signs: shared residence. We do not need to be told about family members. We know what that is. I'm sorry, dear colleagues, I would like to draw attention to all the questions that remains and all the answers on these sessions, and we have only 10 minutes for that. I have a question about why you didn't declare. In 2014, as of the day of declaring, this apartment was not under my ownership and respectively in line with the instructions on completion of the declaration. Real estate shall be indicated as of the day of the declaration completion. As of the day of the declaration completion for 2013, this was the 31st of March, this apartment was not in my ownership. That is, there were no grounds for mentioning this apartment in the declaration. And I think that this is a shortcoming of this declaration. We all remember that the country was shocked when, since 2015, a new electronic declaration was filled in, and this new declaration, eliminated these shortcomings that were present in the old declaration, and no questions emerged in this respect. Exclusively, I was governed by the instructions. I see. So please tell us the apartment at Paladina. What is this apartment, and what are the grounds for acquiring the right of ownership? What the right of use? Who owns it? This apartment, I know that the apartment into which you moved and where these security measures were taken, right? Yes, this apartment was built by my ex-wife. And I have no relation to this apartment. But for some time I lived there. Please tell us. There was a question to you about a gift to your daughter of a private residential house in Kyiv. Did you have any relation to this house, to the ownership or possession of this house? If no, who owned it? And when was it gifted to your daughter? And by whom? As far as I know, and I say this again, information about this house emerged only when I prepared for this meeting, when the PCIe asked me these questions. And I turned with these questions to my ex-wife, and she confirmed and provided the documents that I also sent to the PCIe. This house, she bought this house, as far as I remember, in 2017, and in the same year she gifted it to my daughter, to our daughter. I see. Please tell us, what is this apartment where you are registered at the street of, at Dolbunivska Street? You are registered there, but you do not show it in the declarations as under your right of use. Based on the decision, court decision in 2010, this happened in 2010. This is the first instance court decision. So it passed through all three instances, and while fulfilling it, the administration, Kyiv city administration and Solomyansk district administration, where I was there for 7 years in the list waiting for accommodation, they took respective decisions and allocated this apartment at this address to me. They issued the order for this apartment, and I came there. This house was 90% ready. It was actively constructed. I gave this order to the regional division of the internal affairs. So this apartment was allocated to you due to being there. So as of now, this is a problematic construction, and till now, this building has not been transferred into use. Works have been stopped there for a long time. There was an attempt in 2015 I see that we have very little time with you, and the PCIe members have put you a lot of questions. So please tell us about this land plot with 0.15 hectares, Vita Poštova. This construction agreement in the village of Yurivka, I had financial obligations fulfilled, but the constructors did not fulfill the obligations. I turned to court to receive back the paid funds. The case was also at the stage of execution. Construction workers, companies workers informed that they bankrupted, and basically they could not return all the amount, and they suggested me to accept this unfinished construction, partially repay the funds, and at once they suggested to me that they had such an opportunity for me to purchase this land plot, and I agreed to that. So this land plot was sort of a compensation for failure to fulfill contractual obligations, right? And you provided explanations that your wife was partially repaying the loan, she was helping you, so this was based on some confirmation this land plot was gifted to your daughter. With respect to the gift of the land plot, for this land plot, I took a loan in the amount of 30,000 equivalent of 30,000. It was a hryvnia loan, and I was repaying it according to the repayment schedule. It was not a burden for me, since at that time my salary, my pension, etc., all this allowed me to do that. But I paid 1/3 of the debt. But in 2015, we all remember that what events and what changes occurred. Salary was no longer paid. For 3 months, we received 6,000, and then was inflation. I stopped receiving pension, and I didn't have an opportunity to repay this loan. And respectively, subsequently, there was a stage when the bank had to accept this collateral, this land plot, and take it into their favor, and I informed about this my ex-wife. Thank you, dear colleagues. The session of Yuri Vasilievich, thank you. Do we have any questions from the PCIe members? Yes, please. From free members? Yes, please. Dear colleagues, I have to appeal to all of you. Please refrain your professional selfishness, and remember that we have limited time for all the interviews for all the candidates. And other members of the meeting who... We have 18 members today of the meeting, and everybody might want to ask a question. And we've moved beyond the rules of order, but I provide an opportunity to the PCIe members to ask their questions. Yes, please.
Mr. Chairman, before we do that, I think one of the reasons why we are taking so long is maybe that the candidate is not giving short answers when asked about why he did not declare 2 properties. I think it was only after a few minutes that he even got to the question, and I'm not sure he answered it. So perhaps it's the candidate could be asked to answer questions shortly.
Yuri Sergeyevich, please pay attention to this suggestion. Please provide more laconic and shorter answers if possible. And the answer to the question that is being asked. Thank you. Yes, please.
Thank you, Mr. Chairman. Judge Burbella, if I ask you short questions, I hope you will give me short answers. I want to just briefly review the sequence of events. You separated from your wife in 2003.
No. Our relations stopped. We stopped our relations. We divorced in 2008.
did you separate?
Live apart.
When did you live apart?
В 2003.
In 2003. Even before that.
So, in 2003 or sooner, you lived apart from your wife. In 2007, you were appointed a judge.
Так.
And in 2008, you divorced
Так.
after being separated from your wife for 5 years or more. In 2008, the year of your divorce, and 1 year after you were appointed a judge, you borrowed the equivalent of $90,000 US to buy the apartment under construction.
Так.
That was a 15-year loan. Correct?
Так.
But you paid the loan back in 6 years.
Не я.
Not me, but my ex-wife.
You are asking us to accept that your ex-wife, after you were separated for over 5 years, after you were divorced, gave security of her apartment for your loan, and she helped you pay back the loan. Is that what you're asking us to accept?
Саме це.
Yes. Because it happened like that. I am saying this again. We divorced. We had some property in Crimea, and we decided to divide it like that so that she would repay the loan, and all that property was left to her. That's all.
The property in Crimea, was that the property that gave rise to the court order for the payment to your wife of $136,000?
May I clarify, please, what $136,000 are we talking about? There was a certificate for 2.5 million hryvnias. Are you talking about this?
I understand that the amount received was 6,692,000 Russian rubles.
Я перепрошую.
I'm sorry, I do not understand the question. What you are talking about? What is the certificate?
Certificate which says that there was an award to your wife of 6,692,000 Russian rubles.
Можна подивитись?
May I look at it? I do not remember this. I do not remember that I've provided this. Thank you. Here it is stated. I'm sorry. I apologize. Yes, really, this certificate I just forgot. I had other figures in my memory for some reason. Yes, this is my ex-wife. When I was preparing answers to the questions, she sent me by email this certificate. Thank you. And I've provided it to you. Yes.
How can you make a mistake about 6,692,000 rubles? How can you forget that?
First of all, since it has an indirect relation to me, and it is just to confirm the financial capacity of my ex-wife.
Yes, but you said that you and your ex-wife owned the property in Crimea.
If the question is about this, I draw your attention to the fact that this debt, this indebtedness of the enterprise before my ex-wife, it had no relation to me. I was telling if we had the property at that time, at the time of our divorce, this was unfinished construction, some unfinished constructions in garden allocations on the seaside. That's all. And this concerns some. I've looked through the court decision, and this concerns some share contributions. This is the enterprise. This is Service 22. This is the enterprise in Crimea, the director of which for a long time was my wife since 1999. And this enterprise united several markets in the Yevpatoria, shops, cafes, etc. And this is a large enterprise. But with respect to details of indebtedness, I didn't know that she was the founder of this enterprise. What can I say? Since when I worked, this was a communal enterprise.
Now, my last question. You explained that the certificate was the result of a court order requiring the payment of this large amount. Is that correct?
Yes, I provided the copy of this court decision dated 2013, yes.
2013. All right, those are all the questions I have. Thank you.
Email to the Commission and to ourselves today by noon a picture, a photograph, a current photograph of your ex-wife, please. Yes?
Yes.
Secondly, would you please deal with the question of the gifts? As we understand it, you and your ex-wife gave gifts to your daughter in the sum of some 4 million hryvnia. Do you agree?
I agree. With respect to me, yes, really, this apartment in the townhouse.
Asking you the question, do you agree?
Yes, I agree.
Do you agree that that 4 million was made up of land plots, apartment in Odessa and in the Kiev region, a house in the Kiev region, non-residential buildings? That's what you and your ex-wife together gave to your daughter during amounting to 4 million hryvnia. Do you agree?
Yes, I agree.
Ask one final question. According to state fiscal records, I have a note that your income between 1999 and 2013 is recorded as 793,000 hryvnia. Is this correct?
Please repeat again the amount.
793,000 hryvnia.
Since 1999?
Yes.
Only for the last years, I had more than 300,000 hryvnias of my salary, my annual my annual salary.
So the state fiscal record is not correct.
Ну, я не можу.
I cannot be responsible for this, but I can show the certificate that in my declaration I have all this information. It is necessary to calculate all that, to add all that, but it is a smaller amount than I think.
Period. The State Fiscal Service has a record of your ex-wife's total income as 550,000 hryvnia. Is that correct?
I cannot answer for my ex-wife. I don't know. Based on these records and certificates, I don't know. This is in Crimea. It was issued in Crimea. What income she has in Ukraine right now, what activities she is engaged right now, I don't know that. I cannot explain that. But I know that she, in the Crimea, while we lived there, she always had sufficient high income because she was always engaged in entrepreneurial activities. She was founder of small companies. She was a director of a large enterprise. What else can I say?
Questions. Thank you.
Thank you. Yes, Andrei Kozlov would like to ask a question. Let's start chronologically from the very beginning. In 2008, you take a loan in the amount of $90,000 to purchase immovable property, right? Right. In the same year, according to the NABU's data, on July 17, you purchased a car, Acura RDX. It is not a cheap car, I think. With what funds did you purchase it? I had, before that, I had a 3-year-old car, Suzuki, Grand Vitara XL7. I sold it, and again I took a loan. With what funds did you buy Suzuki Grand Vitara? As far as I remember, you were working in internal affairs bodies, right, Tara? When I bought Suzuki Vitara? No, then I was retired. With what funds did you purchase Suzuki Grand Vitara? In 2005, before my resignation from internal affairs bodies, I bought a car, Mazda 6. Before that, I had car Nubira. I sold it, I added some money, and I purchased. After that, this Mazda 6, it was in a traffic accident. I was in a traffic accident, but basically the car was destroyed. And thanks to selling the remaining parts of this car after this accident, plus insurance compensation. And besides, in 2005, my father died. My father and my mother lived at that time in Russia, in Ulyanovsk region. In Alchevsk, on Donbass, they had an apartment. My mother, in 2005, sold this apartment and divided money between me and my sister. Thank you. I see. You said that you had no relation to the apartment at Paladina Street, right? That this was your wife's apartment. So how is it possible that you had no relation to this apartment if it was a collateral under the mortgage with respect to your loan of $603,000 US. Since my wife lived in Crimea, I lived here. She decided to buy this apartment. She asked me to take this loan since she didn't have funds at once to pay it the necessary amount immediately. I took this loan, and she, during a very short period of time, repaid it. And this was, as far as I remember, it was 2005 or 2004, something like that. Please tell us, again, if we approach it formally, this issue, how is it possible to be to set the property as collateral under mortgage if you have no relation to this? So how did it happen? Wait a second. Circumstances of this loan? No, it happens. No, it turns out no. And how did the bank accept as collateral under your obligation this real estate object? For instance, tomorrow I'll go and take a loan and give your property as collateral. Will the bank accept this? I think no. As far as I remember, this apartment, the agreement, when we concluded when the agreement for purchase of this apartment was concluded, it was registered in my name. But when the loan was repaid, all rights for this apartment in this construction company were in her name. Thank you. Another question, townhouse. This is the premises at Zhambila-Zhambayeva Street or something else? In Yurivka. In Yurivka. Okay. How could you receive this land plot? Did you purchase it, or was it allocated under the decision of the local self-government? The land plot for this townhouse? Do you mean this? In the agreement that I concluded with construction company Kyivgradbud, there was indicated that the land plot was allocated for construction of this house and of this building, and after the end of the construction company would contribute to its registration in the buyer's name. But in fact, this turned out to be false. It was one of the grounds why I went to court to have it returned, because the agreement was concluded with the use of deception. In fact, in this land plot, 5.5 hundredths, only this year my daughter received it, based on the decision of the village council. This is exclusively adjacent territory for maintaining this house, this apartment. And in Vita Poštova, this land plot received as a gift from you. I explained this when builders, constructors, they couldn't return me spent funds, and this unfinished. They suggested me this unfinished construction, and they said that there was an opportunity to buy it at a normal price. This land plot. So it means that they transferred the house to me. They paid me money, but they asked if I was not against this to purchase this land plot. I purchased it, since the land plot is really in a good location. Sergei Yurovich, I'm sorry. I have a suggestion. Let's withdraw questions to which answers have been given. We are moving in a circle. Yes, I ask participants of the meeting who are asking questions, maybe do not ask questions for the second time. The last question. After occupation of the Autonomous Republic of Crimea, did LLC Service 22 continue its existence? As far as I know, yes. Did any of your relatives are among founders of this LLC? The answer to this question is, I learned the answer to this question while preparing for the meeting. Yes, my ex-wife sent me minutes of general meetings, according to which my daughter, as of now, is one of co-founders of this LLC. Do you know whether she receives any income, I mean passive income from being a co-founder? I understand your question, but I refer that what I received and that I in turn provided to you, the members of the PCIe. According to the certificate of this enterprise, Service 22, in 2018 and in 2017, she didn't receive any dividends due to the property situation of this enterprise. Thank you. Sergei Yurovich, may I ask the last question? Yuri Sergeyevich, let's go back to Paladina. Please tell us who is the owner of this apartment. All rights for this apartment belong to my ex-wife. The matter is that, according to the NABU's information, the mortgage agreement was concluded with you. So, again, I have no rights for this apartment. Thank you. Thank you. That's all? May we finish, Mr. Chairman? Thank you, Yuri Sergeyevich, for your sincere answers. The decision will be taken today later. Clear. I ask to invite into the room Holovati Roman Yaroslavovich.
Sergei Yurovich, as you talked that we need to correct our activity, we spent almost more than an hour for this candidate. I accept your point. Thank you. Holovati Roman Yaroslavovich, the candidate for the position of a judge to the High Anti-Corruption Court, we welcome in here. You are present at a joint special meeting of the HQCJ of Ukraine and the PCIe. You have the following rights: to submit motions, to provide written or oral explanations, upon consent of the chairperson to provide your opinions and restrictions, and to give your recusals. Do you have the recusals? I do not have. Thank you. Within 5 minutes, there will be presentation of the PCIe member. Within the next 5 minutes, you will be able to provide your response for this presentation, and within 20 minutes, questions and answers. The presenter on your issue is Mirjana Lazarova-Traskovska.
The reason why this candidate is in front of us is based on the fact that the candidate failed to provide his answers by the 10th of January this year, despite the fact that he was warned that in case he does not provide his answers in time, the members of the Public Council of the International Experts will convoke a special joint meeting with the High Qualification Commission of Judges. The candidate provided us with answers on 11th of January, but without any explanation. On the basis of our questions and his answers and information that we have in our file, we can say that the total income of the candidate for the period of 1998 until 2018 amounted to 1,755,103 Ukrainian hryvnias, and the total income of his wife amounted to 298,055 Ukrainian hryvnias. At the same time, the candidate declared funds on bank accounts of his wife that do not correspond to her official income recorded by the State Fiscal Service of Ukraine. Namely, in 2012, his wife deposited funds to the bank accounts in the amount of 56,219 Ukrainian hryvnias, but her official income, which is recorded by State Fiscal Service, is 24,884 Ukrainian hryvnias, which is less than half of the amounts that were put on the bank accounts. In 2013, we see almost this balance, which goes 10% reports to State Fiscal Services, or 24,093 Ukrainian hryvnias, and the deposits on the bank accounts are 279,755 Ukrainian hryvnias. In 2014, this balance is 349,520 Ukrainian hryvnias on bank accounts, and recorded by State Fiscal Services the annual amount of earnings of 25,421 Ukrainian hryvnias. For the period of 1999 until 2014, the confirmed income of the candidate's wife recorded by State Fiscal Services amounted to 192,945 Ukrainian hryvnias. Explanations provided by the candidate are not satisfactory for the panel of international experts. Namely, I quote, he says, "Funds on bank accounts of my wife were received by her from legal sources at her previous place of work and while performing legal practice starting from 2002, and which were saved in the form of cash funds. With time, documents confirming the exact amount of income were not saved." This is not of satisfactory nature in line with the questions raised to the candidate. Also, the candidate did not provide confirmation of the funds' origin on his bank accounts, in particular with respect to the amount of 399,250 Ukrainian hryvnias that he indicated in his property declaration for 2012. His official income for the period from 1999 till 2012, recorded by the State Fiscal Service of Ukraine, amounted to 360,860 Ukrainian hryvnias. Therefore, there is no confirmation for the amount of 38,390 hryvnias. And this is without taking into account the necessary expenses of their life. The explanations provided by the candidate, again, are not satisfactory because he is again referring to savings in a form of cash funds, and the fact that, according to him, documents confirming the exact amounts of income were not saved. Our conclusion, Mr. Chairman, is that the explanations provided by the candidate about the origin of funds on his and his wife's bank accounts raise a reasonable doubts about his integrity. Thank you, Mr. Chairman.
Дякую.
Thank you. You have an opportunity, Roman Yaroslavovich, to provide your explanations. Thank you. With respect to funds indicated in my declarations, I would like to inform that these are savings of mine and my wife during the entire period of our life. These savings, just like in the majority of cases of our citizens, were saved in US dollars, and they were stored mainly in cash. A part of these funds, about 60,000, were placed at deposit accounts of the bank. Till 2012, I didn't have an obligation to declare my income and income of my family members, since I was not holding positions to which the law on prevention of corruption was applicable. I had this obligation due to being appointed to the position of judge in July of 2012. Separately, I would like to note that I took the oath on December 19 of 2012. The funds indicated by me in declarations for 2012, 2013, 2014 are funds placed at deposit accounts of mine and my wife before being appointed as the judge, and they were saved there during the indicated period. Differences in amounts to which members of the PCIe paid attention are related to the fact that since 2012 to 2014, I withdrew a part of funds from my accounts and transferred them to my wife's bank accounts. This was concerned to other conditions of deposit accounts of my wife. At the same time, in the declaration, I indicated the amount in national currency, and because of this, a significant increase in funds indicated in the declaration is related to the increase in currency exchange rate of US dollar to national currency. In 2014, I and my wife withdrew funds from the bank accounts and stored them in cash in dollars. In 2015, with the beginning of electronic declaration functioning, there was an obligation to declare funds in cash. That's why the cash funds declared by me since 2015 to 2018 are funds that I and my wife withdrew from our deposit accounts, as well as received from the inheritance after my father's death in 2012 and from the sale of my car in 2013. This is what about the funds. I've also received a request to my email about the car and my father's-in-law property. Do I have to explain this as well? Yes, please. Okay. Because I received this request about the car that is indicated in my declaration. With respect to the car, I would like to note that, yes, really, this car manufactured in 2000, I owned it and I declared it in 2012, and it was sold in 2013 for 85,000 hryvnias, and I indicated this in declaration on income, expenses, and financial liabilities for 2013 in section 16, income from the sale of movable and immovable property. With respect to income of my father-in-law and property of my father-in-law, my father's-in-law income indicated in the request of the PCIe members in the amount of 277,119 hryvnias for the period from 1998 to 2017 are the ones that are not correct. Since until 2015, my father-in-law worked in the prosecutor's office, and since March of 2003 till being retired in 2015, he received both salary and pension. Unfortunately, I do not have an opportunity to provide an exact amount of my father's-in-law income for the period since 1998 till 2017. At the same time, in the information note of the NABU provided within the procedure of the qualification evaluation of judges for compliance to the occupied position, appointed with respect to me by the decision of HQCJ dated the 1st of February of 2018, that is included in my judicial dossier, number 03605, it is indicated that salary and pension of my father-in-law for 2013-2017 amounts to 3,544 hryvnias. In 2018, my father-in-law acquired residential premises in Lviv. Based on the agreement on participation in the construction financing fund and in line with certificate 1/10 on the right of acquiring ownership for the investment object dated 19 February of 2018, value of this real estate property amounts to 1,018,996 hryvnias. But the right of ownership was registered not on March 22 of 2017, 2017. This property was purchased by my father-in-law with funds he accumulated during employment, as well as on September 22 of 2015, based on the sale and purchase agreement, there was sold an apartment owned by my father-in-law and mother-in-law and a garage that was also located in the same building. The value of the apartment amounted to 1,892,828 hryvnias, which is confirmed by the sale and purchase agreement for the apartment dated September 22, 2015, and the value of the garage amounted to 29,972 hryvnias, which is also confirmed by the sale and purchase agreement for the garage dated of the same date. Additionally, I also want to know that I didn't know about the NABU's note in the process of this competition. I couldn't look for it. There are some discrepancies in this certificate with respect to my income, since if we take certificate provided in the process of my qualification evaluation, there we saw some discrepancies with respect to salaries and my income amounts. Talking about the period from 2012 to 2018, my income, only my salary, amounted 1,370 hryvnias, 641 hryvnias. Besides, if we take into consideration inheritance and the sold car, it would be more than 1,755,000 hryvnias. That's all I have to say. Thank you. Yes, please, questions? Dear colleagues, do you have any questions? Lytsuk Pavlo Sergeyevich. Roman Yaroslavovich, just now when you've been providing explanations, you saw that you didn't look through the NABU's note. Was there some organizational obstacle for you to look through this note? There were no obstacles. The answer has been provided. Other questions? Vasilenko, Andreevas. Maybe I didn't hear that, but if that's the case, I'm sorry. But the main reason of your presence here, that you failed to provide answers in a timely manner upon the request of the PCIe. What is the reason of that? Why couldn't you provide answers in a timely way? Honestly, I was not checking my email. At the same time, for the last time, I checked it on January the 4th, and the request I received it on January the 5th at 10:41 p.m. And from mass media, I learned that the PCIe referred my candidature to the special meeting, and on January the 10th in the evening, I found this request, and that's why I quickly provided my answer on January 11. And I would also like to know that on January 21, I sent to the email of the PCIe with translation into the foreign language, provided additional explanations, as well as confirmation in the form of some documents about bank accounts that were opened before I was appointed to the position of a judge. Thank you. And in what court do you work? Lychakivsky District Court of Lviv. So this is not a rural area. No, this is not a rural area. Okay, thank you. Any other questions? No questions? Prilipko and then Butenko. One question. Please tell us, before your main income was received before you became the judge, right? Yes, and all this is indicated in my declaration. Did you work as an attorney? For some period, I worked as an attorney, and you earned as an attorney, right? Yes. And what was the system of taxation? Individual entrepreneur. Individual entrepreneur, so single tax, right? Thank you. Butenko, please. Dear Roman Yaroslavovich, you provided explanations about incomes of your father-in-law during this period. Please clarify for how long have you been married, and how have you learned about the wealth of your father-in-law? Since 2004, I've been married. With respect to my fund's property, my father-in-law worked when I married, and in 2015 my father-in-law got retired. And I didn't have enough time to confirm it with some documents. At the same time, I turned to, if we could talk about bank accounts, I turned to the bank to confirm what amounts I had at bank accounts, but unfortunately they said that they can provide this information within 30 days. And the same situation concerns my father-in-law. There is a problem to prove his income since he worked in the prosecutor's office, but time is needed for that. Thank you. Do we have any other questions, colleagues? Yes, Mirjana Lazarova-Trajkovska, please.
President, I was listening quite tentative the explanation of the applicant, and I was expecting that we will receive answer on the documents about the transfer of money, as he said, from his bank account to the bank account of his wife. But so far, we are still lacking proper answer. As we can see from the declared amounts of money on the bank account and money which are declared in front of State Fiscal Service, there is a huge discrepancy. And no documents were provided to the international experts. Could you please tell us how you can support your statement about the earnings of your wife and transfer from your bank account on her bank account, as you've said? And now you're mentioning that there are some other incomes coming from sale of car, but no documents are provided to the international experts. Why so? For the period of 2012, 2013, 2015, because we are speaking about these 3 years.
I see. The matter is that on January 21st of this year, on January 11, I sent my explanations to the email of the PCIE and SQCJ. And on January 21st, I sent additional explanations along with bank statement dated 18 February of 2013 about my bank account and the account of my wife. I don't know whether you received this, but at the same time, these documents were provided by me during the qualification evaluation of judges. At the same time, I realized that this is a completely different procedure, but still these are the documents that I could find within such a short period of time. Besides, with respect to the car was sold, but at the same time, only the general power of attorney was issued in the name of the person who then dealt with its re-registration. Mr. Chairman, yes, please, you have a word.
In 2013, your wife deposited some 279,000 hryvnia on the bank account. Do you agree?
Так.
Yes.
2014, she deposited 349,500 on the bank account. Do you agree?
Так.
Yes.
2013, her income, as recorded by the State Fiscal Service, was 24,000 hryvnia. Do you agree?
Yes, yes. In general, yes. In general, yes.
Her income for 2014 was some 25,000 hryvnia.
About that amount.
The explanation you provided was that funds on the bank account of my wife were received by her from legal sources at her previous place of work while performing legal practice starting from 2002 and which were saved in the form of cash funds. Is that your accurate explanation?
Yes, this is my explanation, right?
Explain how some cash earned in her legal practice ends up being deposited in 2013.
The matter is that in 2013, the period in 2000.
Wait one moment, I'll change machines. If you could wait. I apologize. Did you understand my question?
Yes, I understand it. Thank you. The matter is that, as I've already explained, in 2012, 2013, and 2014, these were funds at bank accounts at the same time until these funds, about 600,000, were at bank accounts, both at my wife's bank accounts and my bank accounts. This was not connected to being the income for the period of 2012, 2013, 2014. This was income before 2012.
I'm sorry. You haven't answered the question. How is it that some cash which she received as at her previous place of work ends up being deposited in 2013 and 2014?
I'm sorry.
Where was the cash kept until 2013? Until 2014? Where was this cash?
At home till 2012. I would clarify this because these are the funds till 2012. The increase in the amount in 2013 is explained by the fact that I withdrew funds from my account and deposited them into my wife's bank account. Deposit agreements conditions of my wife were completely different from the conditions of my deposit agreements.
You didn't give that answer. The answer you gave was that these two deposits came from cash which she had earned somehow long before. Now you're saying it reflects some transfer from your account into hers. Is that right?
These funds, 60,000, this, if we combine funds in 2012, 2013, and 2014, I'm sorry, these are funds, this amount, about $60,000.
All you're doing is not answering my question. Please, one more time. Sometime, a long time ago, your wife had some cash. Yes? You have not produced her tax returns for when she earned this cash. Did she pay tax on it?
No.
So she's got some cash of which she's never declared, and then suddenly she keeps the cash under the bed, and then in 2013, 2014, you deposit it. It doesn't make any sense at all, I suggest to you.
If you allow me, please. The matter is that these funds were earned and gifted and saved, accumulated during our joint life. The matter is that till 2012, I didn't have the obligation to declare them, and that's why I don't have any documents for that. Maybe the State Fiscal Service or the NABU, I cannot comment on the information that they provide. But these funds were not only earned, but also gifted to wedding, birthdays, etc. Thank you. Other questions, please?
Question, Mr. President. It's really confusing to follow you, Mr. Holovati, because in your answer to the international experts, to us, you are stating that funds on bank accounts of my wife were received by her from legal sources at her previous place of work and while performing legal practice starting from 2002 and which were saved in form of cash funds. And now you're saying part of them were transferred from your bank, you sold the car, and etc. Inheritance. Inheritance. But that's what we are concluding from your answer and data from the file is that your wife was declaring to the fiscal services altogether for 2012, around 24,000 hryvnias, 2013 around 24, 2014 around 25 hryvnias. But the bank account was growing year by year. And your explanation in written form is that this was the result of legal practice. If this was the result of legal practice, it should be declared in front of state fiscal services. That's our simple conclusion. Thank you.
I need to respond, I guess, if you allow me. If you have a wish, yes, please respond. I've provided full answers. Unfortunately, I can't provide more detailed answer relating to these funds. Thank you. Andrei Vasilenko, please. Right now, I look at this bank statement of yours, but it concerns only your bank account. As far as I understand, we and the PCAE members would like to see the confirmation of your words, that is transfers and movement of cash funds across your bank accounts. I mean, if you transferred funds from one bank account to another bank account, it should be indicated in bank statements, right? If this is Pump Bank, I have never dealt with this bank, but in Privat Bank, it is possible to do that through the website. Movements of funds at bank accounts. I'm not sure whether it is possible at Pump. So for you just to understand the essence of the question, if you can do that, please do that. You have time through various applications or other means, because we don't see movements of funds at bank accounts in confirmation of your words. And I also have another question. Your wife, what was her position during this period? She worked as a legal counselor at a railway, and for more than 10 years she has been an attorney. And what is the system of taxation that she is under? She is a hired employee in an attorneys association, a hired employee, so she receives salary, right? Yes. And individually, she is not performing as a self-employed person. At the beginning, she worked like that for some time, but I cannot recall the year. And she is not working as individual entrepreneur, right? Yes, right. Please, do we have any other questions? Thank you, Roman Yaroslavovich. A decision will be taken later with respect to you. Please have a rest. We have a request to announce a break for 15 minutes, and I announce the break. Let's continue our meeting. I ask the Secretariat, can we work? Thank you. Please invite into the room Жовноватюк Victoria Sergeyevna. This is Жовноватюк Victoria Sergeyevna, the candidate for the position of the High Anti-Corruption Court. Welcome, Victoria Sergeyevna. You are present at the special joint meeting of the High Qualification Commission of Judges of Ukraine and the Public Council of International Experts. You have the following rights: to submit motions, to provide oral and written explanations, upon consent of the chairman to voice your opinions and objections with respect to the considered issues, and to give recusals. Do you have recusals as of now? Good afternoon. No, I don't have them. Thank you. 5 minutes for the presentation of the PCIe member. 5 minutes, within 5 minutes, your response. And within 20 minutes, explanation, answers and questions. So the presenter on your issue is Ms. Lorna Harris. Yes, please.
Thank you, Mr. Chairman. There are two aspects to the PCIE's doubts and concerns in this case. I will deal with the first of them, and the PCIE Chairman, Sir Anthony Hooper, will deal with the second of them. In this case, the candidate, who has been a judge in the Slomiansky District Court in Kiev, was a judge during the proceedings, the ongoing proceedings against Mr. Nazirov, who I'm sure you all know is a former head of the State Fiscal Service. This, we understand, has been a very high-profile case for Kiev and for Ukraine, and it has been perceived as important that the case should proceed as smoothly as possible. And by way of further background, I think I should say, particularly in respect of our role, that it has been a case which added pressure to the government to implement new anti-corruption legislation. The aspect of the case that I deal with concerns social media. While the proceedings were ongoing, the candidate posted on her Facebook page on the 31st of March 2017 a reference to an article about the proceedings with the headline, "Why NABU is putting pressure on the court considering the Nazirov case." She has been asked about this, and in response said that she did admit that she'd posted this article, and the article was attached partially in her answers. However, what she sent to us was an edited version of the article, and we have had the benefit of reading the whole article. And within the bits of the article that she did not send to us, there was express criticism of NABU's role in assisting bringing the case to court. During the rest of 2017, this candidate, during the ongoing proceedings against Mr. Nazirov, actually became an investigating judge in the case, so she was herself involved in the prosecution. She made a number of decisions in that capacity during 2017, starting on April the 27th. And on the 27th of December 2017, she again posted a reference on her Facebook page to the case. On this occasion, she referred to an article and headed her post about justice in Ukraine and how publicity affects high-profile cases, recommended for reading. The article referred to is headed, and I quote, "Nazirov was arrested just like Lutsenko, famous lawyer." End quote. The article contains an interview with Nazirov's lawyer, Igor Fomin, and the candidate defended to us her post by stating that her post was not a public comment of the matter pending before the court. Again, she sent to us extracts of the text of the whole article. But again, we have looked at the article in its entirety. And if I may, Mr. Chairman, I would like to read out two short quotes from the bits of the article that were not sent to us. In the first case, she said, the article that she did not send to us, but which was referred to in the post, said, "Probably I will be unpopular, but I wonder why create an anti-corruption court? To blush your eyes with the new illusion of fighting corruption? If it is rude, then corruption crimes are 5 articles in the criminal code." So there was an express criticism of the administration of justice. And then later, she says, "Society has to show results. You have created us to fight corruption, and we fight it. They need bright persons involved." And the lawyer says, for example, the head of the Fiscal Service, Mr. Nazirov, "Yes, they need suspects of this level instead of searching for the truth. It's PR." Mr. Chairman, I refer to Article 20 of the Code of Judicial Ethics. We've heard of this before. It is acceptable for a judge to have a social network account, of course. But a judge should only post and comment on information which does not undermine the authority of a judge and the judiciary. In all the circumstances, those posts referring to the extensive articles which were selectively quoted to us, in my view, are quite clearly undermining the judicial process.
Thank you. Mr. Chairman, please continue.
I'm now going to deal with some decisions, a decision that this candidate made, and I'll take it slowly. It concerns NABU, which of course is the subject matter of criticism in the articles to which Ms. Harris has referred. On the 27th of December of 2016, this candidate granted NABU access to data on an account, I have the number if necessary, of Oshad Bank, which was under criminal investigation. So she granted NABU access. On the 23rd of January 2017, just a few days, about a month later, this candidate changed that decision ex parte, in other words, without the attendance of the prosecution and without their consent. And she granted NABU access to that account, but only in regard to some bank clients, Creative Joint Stock Company, Creative Agro, KMZH, Creative Group Stock Company. So she narrowed the court order right down. In order to justify this change, as I understand it, the candidate said that she was making the change under the provisions of Criminal Procedural Code that allow judges to correct spelling errors. For example, the incorrect name of a party or something like that. But our concern is that the candidate made a substantial change to the decision that she'd given in favor of NABU by narrowing the scope of the data to which NABU could have access. On the 23rd of February of 2017, the Kiev Appellate Court quashed her decision because she had not informed the party about the hearing, thus giving the prosecutors no occasion to object to the change that she made herself on her own. Subsequently, after the decision of the appellate court, another judge gave access to the data on that account in the same form as this candidate had originally ordered. But of course, the consequence was a significant delay. That her decision raises, in our view, a reasonable doubt about her integrity and professional skills. Thank you.
Дякую.
Thank you. Please, Victoria Sergeyevna, you have an opportunity to respond. Thank you. If you may, I would like to provide the PCAE members in the paper format with my explanations that I sent in a timely manner so that it would be convenient for you to follow what I will be saying to you, if you have no objections to that. Mr. Chairman, this is what I sent to you.
If the candidate is referring to documents which were sent in answer to us, to our questions, then we have those already.
Okay, there is no need. Okay, thank you. Thank you for the opportunity to provide personally my explanations to the questions that you had with respect to me. Yes, I'm a judge. I have my account in the social network of Facebook. Due to the fact that trust in the judiciary is not very high, and in particular in judges as well. All this made us judges stop hiding in our offices and enter the public domain. In the social network, Facebook, we started telling about ourselves, about our lives, about our professional lives, about peculiarities of this life, about our private lives, so of course within the scope of the allowed. We started showing that we are a part of the society, that we are not some separate group of people with our own shortcomings, of course, just like any human being, with our faults, with our aspirations and dreams. We started managing blogs where we raised topical issues. And as it has turned out, these topical issues are topical not only for us, but for the majority of our society. And in such a way, I think that we started contributing to the fact that trust to us has started increasing. If you look through my personal page in Facebook and its history, I hope that you will not find there any violations, ethical violations that are inadmissible, some phrases that are not allowed. I never allow myself in my virtual community, in my virtual life, to say any comments of any civil, administrative, criminal cases, the consideration of which is still ongoing. Mostly I publish on my webpage important questions relating to judicial practice. Our Supreme Court has its own page, and this is very useful. That it briefly posts legal positions and posts its comments. People can observe it, and subscribers can observe this. It is very convenient when you go back to your page and you study these legal positions with respect to those topics that interest me. Attendance of different forums and consequences of decisions, this is also highlighted. There is some educational direction that I am trying to highlight, in particular my training activities at the National School of Judges. Recently, I've been participating in educational activities of scholars, pupils, and I participated in the Year of Justice. This is the all-Ukrainian campaign conducted within the scope of the grant project of increasing awareness of children about judges' activities with support of the USAID. Within this project, the president of our association developed a multiplication video. Victoria Sergeyevna, if you may please go back to those issues and those questions that have been person asked. Yes, this is my line of direction, and that's what I wanted to inform you about my conduct at my personal Facebook page. Going back to the comments of the presenter that I sent you only edited versions of the articles, I would like to say, to highlight with these experts the points to which I paid attention in these articles when I reposted them. But this was in March and December of 2017. But when you paid attention to this and when I directly looked at these posts, I agree with you that it was a very sharp formulation of the name of the article by journalists, and of course it may have a double interpretation and perception of this article. With respect to the activity regulation of the judges' activity in the Facebook, Article 20 of the Code of Judicial Ethics, but it has a more broad meaning. And that comment that is present with respect to this article cannot, of course, envision all the instances that may happen in virtual life of the judge, but still, in any it concerns more general phrases to be correct, to be polite, to hear other people's views, not to post images, photos that may look too open, but there is no standard of the judge's conduct in social networks in our country. And I agree that, yes, it is easier not to be present on the social networks rather than to undertake some additional restrictions. And I agree that we learn from our mistakes that we commit while being there. If we talk about governance of the judges' conduct in well-developed democratic countries, for instance, the USA, there we have a code of conduct of judges in the USA and of employees of judicial bodies. And besides rules governing in these codes, there are consultative opinions of committees on conduct. And they not only interpret some rules of conduct, but they also, even I've studied them, circumstances of disciplinary proceedings on the judge's presence in the social networks in particular. And while studying this, one can develop the line of conduct and follow this conduct. With respect to directly rules, even in these rules, there is a norm governing conduct of judges with respect to cases that are still ongoing. And based on interpretation by these committees, there are different, even in the USA, there are different opinions with respect to this interpretation, ranging from the one that one cannot comment about the essence of the case that is still ongoing or is going to court, or and to radical interpretations when one cannot, one has to avoid any mentioning about the judiciary. I would like to emphasize again that those in the explanations, I provide experts from these publications, and I haven't concealed it, because when I directly made this expert, I indicated at the above that this is what I paid attention to. Besides, in these explanations, I explained to what preceded my reposting and this interview. Some events that were taking place. And the first publication, I would like to draw your attention to this. It concerned more activities of our court which I considered to be necessary at that time to inform the society, the public about this. With respect to the second publication, yes, there is such a reference which the PCA member has mentioned, but again, I would like to note that those messages to which I paid attention while reposting it are slightly different. But I agree that, yes, really, it may be perceived like that, and one should try to avoid that in the judge's activities in the social networks. With respect to the second comment, the second issue presented by the second presenter, unfortunately, I will not be able to answer this today. Yep.
Very long decisions. I'll give the candidate all the decisions except for the final one, which I don't have, which related to some other judge.
Yeah.
And that it's very easy for you all to access these decisions if the candidate gives you the number. There are 3 decisions she's got. Her first decision, giving a wide order. Her second decision, narrowing the order right down on her own without the prosecutor present. And then the third decision of the Court of Appeal. All 3 are now in the candidate's possession, and I'm sorry I wasn't able to give this information earlier.
Mr. Chairman, does the candidate see this for the first time? Maybe we should give her some time to look through these decisions.
She sees it for the first time, except for it's her decision.
I don't need time. Okay. May I answer? Yes, please. With respect to the question dated December 27 of 2016, as we see from the text of the decision, there was consideration of a motion of the detective on temporary access to documents and things. The presenter noted that the decision was taken, then a spelling mistake was corrected, and then the appellate court cancelled it, squashed it, and then he paid attention to that other investigative judge satisfied this motion in the same scope. I would like to note that under the Effective Criminal Procedure Code, there is no limitation with respect to the number of the times the prosecutor or the defense party can submit any motions to any court. What I can say to justify myself, that maybe the second judge was provided with a larger number of documents based on which he took the decision on satisfying the motion in the scope that you are telling about. About the capacity to correct the mistake and the absence of the prosecutor. I would like to say that during the first hearing, the prosecutor was not present as well. The detective submitted the motion upon consent of the prosecutor. This is also the provisions of the code, and presence of the detective was sufficient in this court hearing. That is why, in order to correct the spelling error and to call prosecutor for that, it was not necessary, in my opinion. The other point that I would like to draw your attention to with respect to this decision, that under the Effective Criminal Procedure Code, correction of a spelling mistake is allowed both upon the initiative of parties to the proceedings and upon the court initiative. In this case, this number of cases and proceedings that are considered do not allow to trace all the decisions that have a spelling mistake. As far as I understand, there was an application of a person. If this is temporary access, the temporary holder of those documents to whom this ruling was addressed, it was heard and the decision was taken. With respect to the operational reconsideration, the code doesn't envisage procedure reconsideration on temporary access to documents and things. What happened under this appellate I'm sorry. Appellate consideration is not envisioned except for cases when documents are extracted. As we see the motivation part of this decision, of the appeals court, yes, there is a reference that provisions have not been complied with because under the provided materials of the proceedings, participants of the case were not informed about the date and time of consideration of on the correction of the spelling mistake. Unfortunately, I cannot comment on the decision of the appellate court, but I can state that the party to the proceedings dated 27 December of 2016, when the motion of the detective was considered, the prosecutor was not party to this proceedings. That's why I had no grounds to inform him.
Mr. Chairman, I have a number of questions about these decisions at some time suitable to you. Shall I go now?
Прошу.
Yes, please.
On the 27th of December of 2016, at the request of a detective with the consent of the prosecution, you granted NABU access to data on the interim account 191992 of Oshad Bank. Do you agree?
Так.
Yes.
The detective was requesting.
The matter is that right now I don't have materials of the case with me, and in particular the motion that was considered.
Yes.
Or your reasons. Just look at your reasons. You granted the detective prosecution the request that they could have access to data on the account which I have given. Do you agree?
Yes.
Then, on the 23rd of January 2017, you changed that decision. Yes or no?
It was not changed. A spelling mistake was corrected, if you may.
Listen to me. You changed the decision.
May I explain, please?
With respect, it's a simple question. Did you change the decision? If you say no, I will come back to you. Did you change the decision?
If we talk about the first and the second decision, yes, it was changed in the resolution part.
What you did was you did not give NABU access to all the accounts, but only to some accounts. Do you agree?
Так. Ой.
How on earth did you know to exclude other accounts but allow these through? How did you know that? So, you understand my question? I'll do it again. You allowed through the accounts relating to about 4 bank clients, all with the name, I think, Creative or Agro, 4 or 5. So how did you know on the 23rd of January, when you changed this, to give these names but exclude all the other names? Where did that information come to you from?
From the application submitted on correction of the spelling mistake in this decision. The matter is that when this motion was considered, this question was studied during the court hearing. However, while producing the text of the decision, and in particular indicating in the resolution part particular accounts, there was a spelling error made. And when the person had this information and provided these circumstances in the statement, then it was taken a decision to about the necessity to change, to correct the spelling error in this particular court decision.
It isn't a spelling error to change an order from access to the account 191992 to access to an account only in regard to 5 named account holders. That is not, I suggest to you, a spelling mistake. Do you agree?
I agree that while taking the decision, I made this mistake. I agree with that.
So you changed the order. I'm asking you, how did you know how to change the order? How did you know how to include some accounts but exclude others?
Exclusively based on the statement that was submitted. There was court proceedings initiated on correction of the spelling mistake, and in this statement, the person who submitted this application, this is a holder of that information, access to which I granted. This is Oshad Bank, and a representative of Oshad Bank provided the circumstances that I considered, and I took this decision.
So now we know the bank came along and saw you privately and said, please alter your order so that it only covers these clients. Is that what happened?
No. No. May I explain, please? The matter is that while considering the motion on temporary access to items and documents, there were studied those documents that were directly attached to this motion, and with respect to all these accounts that I indicated here, the holder of this information in this case was Oshad Bank. And when
Did Oshad Bank make a submission to you in writing or orally that you should change the order?
I'm not ready to say that right now.
You've just been saying.
No. They could not provide oral statement, but to say that what materials in these proceedings were present, I cannot unfortunately do that right now.
Something even worse that you did, because when you made the order, you wrote, the court decided to satisfy the request of the detective, and then you limited the order to these 5 accounts, even though the detective had asked for access to all of the accounts on that numbered account of Oshad Bank. So that was a misstatement by you to suggest the detective had asked for that when he hadn't. The detective had asked for all the accounts, and that's what eventually the judge was going to give. Do you agree?
That subsequently the judge, another judge provided this. I cannot unfortunately comment on this.
Suggest you, I want you to think very carefully about this. No application was made to you before you changed your opinion. No application was made. You have changed your opinion because of something that you have been told or you have learnt. Nothing to do with any application for a spelling error. Do you agree?
I have not understood the question in full.
You have told us, as I understand you, that an application was made by someone in respect of a spelling error. You have also told us that you received information of some kind or another from Oshad Bank. I don't know how you got it. I'm suggesting to you there was simply no application about anything. You yourself decided to restrict this order following some form of intervention by someone. No application made.
With respect to intervention, I categorically deny this. I would like to draw your attention again that I cannot remember and provide you with explanations of circumstances under which this decision was taken. However, the effective criminal procedure code envisions this opportunity to correct the spelling error.
Sorry, just repeating. Is there any reference in your second judgment changing it that an application was made? And if so, who made the application?
There is no reference.
No reference, thank you. Those are my...
Yes, Ms. Lorna Harris, please.
One very simple question. From April 2017 until the end of 2017, were you an active investigating judge in the case of Nazirov?
In May of 2017.
В травні тільки.
In May, only in May.
Did you take in May?
Ну, з урахуванням тих пояснень.
Take into consideration the provided explanations, I think 4. Yes, 4. About 4.
Your role, was it possible, at least theoretically, that you could be asked again to carry out investigating judge role throughout 2017 and indeed later?
Справа в тому, що
The matter is that in 2017, in July, my authorities expired, my authorities of a judge expired, and I was not fulfilling these authorities, and I considered no cases after that.
Дякую.
Thank you. Other questions, please? Vasilenko and then Kozlov. Please tell us. So, the materials of the case. Who was the initiator of your proceedings with respect to the correction of the spelling mistake? Who? If you say that if you write in the decision this was upon the initiative of a detective, was it the court's initiative? Why in the decision you say that the spelling error was corrected based on the initiative of the detective? It is not indicated. There is a reference to the provisions of the law. It is difficult for me to say that right now. I have to look through the materials of the case, but unfortunately it is not indicated. And what is indicated? There is a reference to Article 379 of the Criminal Procedure Code about the possibility of correcting spelling mistake in the court decision. But with respect to this issue is one of the key ones right now, where what legal fact was initiated these proceedings? What legal fact became the ground? What became the grounds for taking this decision? That is the statement. If this was the initiative of the court, then the question, then I support Sir Hooper in this respect. Then we have another question. Where did you get the information about accounts, etc.? This is the first item. The second one. Please tell us what your first court decision. What access to accounts to whom and what accounts? Access, temporary access. The first ruling, the first decision concerned access. 1 second, please. Legal entity Ощадбанк. Some information about movement of funds, documents, primary documents. Please read aloud the resolution part. It is quite extensive. That's okay. Motion of the detective is satisfied to provide detective indicated temporary access with documents that contain bank secrecy with opportunity to look through them and make a copy of them that are held by legal entity JC Ощадбанk. Details are indicated, and here we have a list of accounts. Information about movement of funds, the bank accounts, a number is indicated, the currency is US dollar, and the holder of which is Ощадбанk for the period from 2014 to the moment of the motion consideration, and counter entries are indicated, details are indicated, etc. The list. Documents of primary financial monitoring, as well as documents submitted to the National Bank of Ukraine of the financial service of monitoring with respect to financial monitoring of the above indicated transactions on the accounts, the holder of which is a bank. Primary documents that show the depositing and withdrawing of funds, indicated number of the bank account, dollar is the currency of the account, the holder of which is Oshad Bank for the periods until the motion consideration. In the brackets, we have invoices, receipts, cash receipts, on the receipt of cash, etc. The duration and validity of this ruling is determined. And in what part was there a spelling mistake, and what was that spelling mistake? Decided to correct the spelling mistake indicated in the motion of the investigative judge in paras 3, 4, 5, in particular to provide the DKF with temporary access to documents that contain bank secrecy exclusively with respect to clients of the bank, and the clients are indicated, LLC and names of these clients are indicated, with an opportunity to look through them. That is, in this ruling, take into consideration the motivation part 1 of the ruling where the spelling mistake was corrected. It is indicated in more detail that under the indicated bank account, with respect to which enterprises information has to be provided in order not to violate rights of other persons, as it is seen that this account concerns a wider circle of legal entities, but since the pre-trial proceedings were concerning these particular entities, it was done in order not to violate the rights of others. Yes, these are internal banking accounts that, in the broad formulation, these are basically the allowance for the detectives to get acquainted with the entire activity of the bank and all the clients of the bank, and not only those who are mentioned in the criminal case. But still, there is a question of initiative. There is also a question. You said that detective was, not this detective was present at the court hearing. Or were you doing in written proceedings, correcting the spelling mistake, with participation of a detective and secretary? So the detective was present at the second court hearing, while the spelling mistake was corrected. I'm talking about the second one. Second one was with participation of the secretary only. So you were doing it in writing, so to say, right? So here we still have the question about the initiative. Who initiated this, and where did you get this list of persons, of entities with respect of whom you granted access? Thank you. May I answer? With respect, I will start from the very end about the list of entities indicated in bold and exclusively with respect to these entities. They are all listed in the motivation part of the first ruling dated December 2016. Since this account access to this account could violate rights of other persons who are not mentioned in these criminal proceedings, this particular reference was made. And I would like to repeat again with respect to the initiative. It is envisioned by the Criminal Procedure Code that it can be done upon own initiative and upon initiative of the parties to the proceedings. But unfortunately, in this case, since the documents have been provided to me right now, I cannot answer this question like I would have been able to do that if I had case materials. I could turn to court, to the head of the apparatus, take this case, if it hasn't been destroyed yet, look through it, and then I could provide more detailed explanations. But unfortunately, as of now, I can explain it only upon looking through these particular documents. I have a suggestion. Till evening we have time. the second interview or break, maybe we shouldn't do that, but if there is an opportunity to look through the documents, I would like to look through these documents. If you can do that, I will try to do that. I have a suggestion for us to be provided with these documents. I need to ask participants. Yes, please, Lutsuk Pavlo. Dear colleagues, I think that this would be fair to support the position of my colleague Vasilenko, and I will tell you why. The candidate explains that she can look through the case materials and provide detailed answers to those issues that have been voiced by the PCAE. The PCAE has established such a procedure, and we see that with practice support that the documents provided to them after their deadline, they do not accept these documents, but there should be some parity, and that's why I think in order to be fair and just, maybe we should ask the candidate as well how much time she needs for that, but I would support a suggestion of candidate Vasilenko that upon consent of the PCIe, such time, maybe 2-3 hours, should be provided to the candidate and announce a break and go back to this meeting at the end of our day. No, on the contrary, I say that no break should be announced by us. This is my suggestion. I would like to see the documents of the proceedings that confirm or that show or from which it is seen that the ground of correcting the spelling error and who initiated this. This is what I want to see. I don't want to announce the break. I didn't suggest to make a break. About the procedure of the PCIe, this is not only the PCIe. We also do not accept these documents, and we've agreed on this with the PCIe. I'm sorry, I will clarify. Maybe I've misunderstood, but if we provide the opportunity to her, we also need to have a break or postpone or in some other way, not to consider other cases and wait until she looks through them to go to court. And I think that we should clarify. Why should we have a break in the deliberations room? We will look for these documents, read them, and we'll make some conclusions. That's all. Thank you. Yes, Kozlov, please. I have to say that maybe these rulings are present in the Unified Register of Court Decisions, and we can look for them in the deliberations room. These materials are available. No, I'm not talking about that. I'm talking about case materials. I'm saying about... shouldn't the decision mention who was the initiator of correcting the spelling error? But we see that no. Dear colleagues, let's not start the discussion. Please, Mr. Chairman, what is your opinion on this?
In my opinion, she should be allowed to look for any document which makes clear how on earth it was that she changed not just a spelling error, but changed the whole order made. If she can produce some document, that obviously would be helpful to us all.
Thank you. If you remember, as far as I understand, between two rulings there was about a month, right? 1 month, right? Did you study the question relating to execution or fulfillment by NABU's detectives of your first ruling? Did they hold any investigative actions with respect to these accounts? Did they receive necessary information within this month? Without the case materials, it is difficult for me to say about that. But if you allow me, I would like to add and to address the presenter who asked this question. If we look at the resolution part of this ruling, the number of the account has not changed. there is only a note that exclusively to the clients of the bank, and there are indicated 1, 2, 3, 4 legal entities.
To which I have been referring and asking you over and over again.
I would like to draw your attention to the fact that the motivation part of the first ruling, when the motion was considered on access to things and documents, it concerned that the body was conducting proceedings where these 4 legal entities were mentioned, and the access to the account to which access was asked for in that version. In the first court ruling, it allowed disclosure of information of an unlimited circle of persons. Since I considered within the question of these persons, this clarification was made. Let's say it was a clarification of this decision by means of correcting the spelling mistake. In this particular case, the content of the decision did not change. As the detective insisted on having information about these legal entities, in this case, the decision was taken like that. Thank you. Dear Mr. Chairman,
To enter into any further debate with this candidate who's now giving a completely different account of what she said earlier. I just think she ought to have the opportunity to produce some document which explains how it was that she made the changes she now accepts that she made.
thank you, Victoria Sergeyevna. How much time do you need to prepare for us these materials? To go to court, to find the case, and to go back to you. The matter is that we have 2 buildings in our court. I will try to find where this particular case is located. So until 4, until 5, how much time do you need? Until the moment we go to the deliberations room. So you have time till 5 p.m.
Just ask 5 p.m. I would just ask for our documents back, please, but please, if you want a photocopy of them, we can make them for you. Would you like a copy of those?
Звісно,
Yes.
звісно,
Could you do
хотілося б.
that?
Можете це зробити?
Дякуємо. Чекаємо вас.
Thank you. And we are waiting for you till 5 p.m. I'm sorry, Victoria Sergeyevna, I would give you a recommendation. You should call the court operators. They should start looking for a case until you get there, and then you will come and get the ready case. Mr. Chairman, I have a question to you. Do we announce a break, a lunch break right now?
Шановні колеги,
Dear colleagues,
If you'd like to do one more candidate, please do. On the other hand, it's 1:45, but if we're breaking now, could we start again at 1:30? So a quick lunch break. Because we lost time this morning because of the snow and things like that, and also we've had long... We've only done 3, so we've got a lot to go. But I leave it to you, Mr. Chairman.
перша 40.
at 1:45, because of snow.
We just discussed the possibility of making video by BBC. We permit it. BBC, you are welcome. Hello.
Dear colleagues, let's continue our meeting. Our special joint meeting of the High Qualification Commission of Judges of Ukraine and the Public Council of International Experts. And I ask to invite into the room candidate Zanini Diana Volodymyrovna. Zanini, I'm sorry. This is candidate Zanini Diana Volodymyrovna. Welcome. This is a candidate for the position of Judge of a High Anti-Corruption Court. You are present at the special joint meeting of the High Qualification Commission of Judges of Ukraine and the Public Council of International Experts. You have the following rights: to submit motions, to provide oral and written explanations, upon consent of the chairman, to voice your opinions and objections with respect to the considered issues, and to give recusals. Do you have recusals as of now? No, I don't have. Thank you. 5 minutes for the presentation of a PCAE member. After that, within 5 minutes, your explanations, and after that, within 20 minutes, session of questions and answers. Yes, thank you. Please remember that our interpreters also work with us. We have simultaneous interpretation, and that's why I ask you not to talk very quickly. We will have time for everything. The presentation on your issue is presented by Mr. Fleming Denker. Yes, please.
The PCIe has decided to refer the question of the candidate's compliance with the criteria set out in Article 8.4 of the Law of Ukraine on the High Anti-Corruption Court to this special joint meeting. And the concerns the PCIe had in relation to this candidate is following. The candidate has been working as an attorney and conducting law practice since 2008. From 26 February 2014 to 30 June 2016, she was also engaged in entrepreneurial activity associated with the sale of pasta, and income in 2014 was 80,144 guineas, and in 2015, 326,370 guineas. From 1st July 2016 to 27 April 2017, she started activity in the field of law. She has explained that she didn't receive any income. From 27 April 2017, she terminated her activity in the private firm DV Zanini. From August 2017, she has been resident in Italy. From 17 October 2018, she was registered as a self-employed person in the general taxation system, engaging in legal practice. According to the information from the candidate, she didn't receive any income in 2016 and in 2017, as most of the legal cases she started to conduct before leaving to Italy in August 2017 are still ongoing. While in court, and according to arrangements with clients, her income can only be obtained at the end of the case hearing or following a court decision and collections from the defendant, or when achieving a positive result for the client. The second question is, the amount of $6,000 belongs, according to the explanation from the candidate, to her and is saved by her throughout the whole period and not exclusively for the year of 2017. Her single source of income was the sale of shares by her husband. As documentation, there are sent some print screens of his online account showing 2016, 2017, and 2018 earnings. The income from trading activities is volatile. The income is of a periodic nature, and therefore the losses in 2017 should be considered together with the income of the previous and current periods. Besides, she notes that her husband has been engaged in trading activities for a long time, and he has savings for which one can live, even if there was a year that didn't bring income. Conclusion: the candidate's explanations about no income in 2016 and 17 and about her husband's financial situation in 2017, including his selling and buying of shares, without account showing his whole financial situation, including other potential income and property in general, are very unclear. It therefore leaves reasonable doubt about her integrity. Thank you.
Дякую.
Thank you. Dear colleague, Diana Volodymyrovna, you have an opportunity to respond, please. Thank you. May I be answering not in that order, but in another order? Yes, thank you. I will start with respect to income of my husband. In order to clarify all the questions and issues that emerged, as well as I would like to, after my presentation, I would have a motion on attaching evidence. I would like to read out his letter statement that he provided upon my request before, while I was preparing for this meeting. If you allow me, I will read out his letter. I, Zanini Massimo, who signed below this, provide this exhaustive statement on my property and financial situation in order to have an opportunity to dissipate doubts with respect to this issue. I'm the owner of apartment according to the attached excerpt, and I will provide this excerpt later. Received in the residential complex in Comuna Lazidze, where I reside since 2007. The purchase of real estate became possible also thanks to the financial assistance of my parents. All payments are all traceable and have been done through the bank, since we are talking about construction under the agreement. My father worked in the tax police, financial guardian, and when he retired together with other two partners, they constructed and managed a restaurant in Lazidze for 6-8 years. After that, it was sold as a real estate and as business. I managed for almost 10 years, since 2003 till 2012, the restaurant in Verona, together with my partner, receiving constant income. In 2013, I exited the company in order to move to Kiev. I'm the owner of two current accounts. One of them has a small deposit in euro without a credit card and is used for daily needs, while the other account in euro is multi-currency account for depositing of securities and is mainly used for trading operations and the use of the credit card. Trading activities is not professional and they are performed. The bank performs the functions of a tax agent for, with respect to the tax part, which is deducted from the income, and I performed these activities for about 20 years. As of today, this is my only source of income. For the last 3 years, I submitted reports on such income from trading activities. In 2006, my husband, for 2016, my husband earned, and I'm adding this from myself, 50,760 euros. In 2017, he had losses in the amount of 21,864 euros. For 2018, he earned 57,506 euros. This data can be looked through in the provided attachments. Besides, while analyzing bank statements, we can see that the above-mentioned amounts turn out to be absolutely accurate, and in the details of the trading securities it is also indicated. However, differences for 2000 months are characterized also the amount of the impact of changing currency exchange range and family expenses on monthly amounts on that. As of now, I receive no financial assistance from the state institution, including subventions, subsidies of any nature. I do not have, and I have never had, information about being convicted and criminal prosecutions. I do not have, and I have never had any court hearings with Italian tax bodies. The time that I have is limited, and it has allowed me only to explain my property and financial situation with a few lines. But if it is necessary, I am ready to call you by Skype to explain everything in detail. If there is a prior notification, I can also participate in a meeting. With the best regards, Zanini Massimo. I would like to add that I have, along with this statement, and I provided before that pre-screens about amounts that were voiced by me. It is clear that having the income for 2016, having official income, everything goes through the bank, and I have a bank official statements for that, and I had an opportunity to come to bring right now because I was asked questions by means of sending me an email to my email. I had to respond very quickly, and in view of this, I provide print screens from his bank account, where it is seen that the name of the bank as well as amounts that he earned. I think that his total amount in the amount of 50,000 or 57,000, like in this year, is sufficient for even some years. There is a situation that his has the minus balance, but his income for the previous years cover these minuses and losses and allow to have a normal life. Besides, I would like to note, as I've already read out from his letter, he engages in these activities for over 20 years. These amounts that I've just provided are only an example of his annual income. In order to prove this with evidence, I also attach a statement. I have statements for 2016, 2017, and partially for 2018. Besides, I also have the last month of 2015. I have official bank statements with signatures, and they've been provided by a bank in a format of PDF, with digital signature of the bank representatives, and I can provide completely all these bank printouts, where you can see all earnings, all he has earned, all he has at the current account, at multi-currency account, as well as the number, the amount of shares, not the amount, but for which amount he has shares of the company. If necessary, I can voice in more detail with respect to amounts that I've provided printouts and print screens and how it corresponds to his bank statements that I will provide after my presentation, if I am allowed to do that, if my motion is approved. Now, with respect to my income, I'm sorry, not income, but savings, in the amount $6,000. I provided these explanations. In particular, the fact that this amount is are all my savings. I've been working since the age of 18, and I've also had part-time jobs since 14. That's why what I indicated in my declaration is these are my savings, not my income for 2017. These explanations have been sent by me in the written form. So, with respect to my income, yes, really, in the declaration I indicated about the absence of income in 2017. Since in August of 2017, I moved to Italian Republic. Till August of 2017, I had some attorney's cases under agreements of 2015, 2016, and 2017. But according to arrangements with my clients, the income I will receive the income after the end of the court consideration or upon receiving a positive result for the client. This decision about financial relations between me and clients was taken due to the fact that clients were either friends or acquaintances or some relatives. Take into consideration the fact that mostly under most attorneys' agreements dated 2015, 2016, and 2017 are still or were still in court instances as of 2017. In 2017, I received no income from these cases. Besides, I would like to note that some cases, upon preliminary agreement, were managed by me free of charge when I saw that among these acquaintances or relatives that people had a difficult financial situation, and moreover, there were some problems that called for legal intervention. In order to confirm this, I also have provided additional supplementary agreements on legal assistance provision agreements that I've provided as attachments to the statement on admission to the competition. And they're also included into my dossier. So, taking into consideration the income of my husband, I have a physical opportunity to engage in professional activities for the sake of supporting my professional level and skills without being worried when in particular I will receive income or whether I would receive income at all. This is briefly all I have to say. If you have any questions, I will gladly answer them in more detail. Thank you, Diana Volodymyrovna. A question from Mr. Danker. Yes, please.
Thank you very much. I would like to put the first question to you. You moved to Italy in 2000 in August 2017. Is that correct?
Так.
Yes.
Why did you move to Italy?
Тому що
because my husband is an Italian and we married in 2012. After marriage, since 2013, we started living in Kyiv. And my activities as individual entrepreneur and the sale of fresh Italian pasta was not very successful. And due to this, and we rented the apartment here, when the rent was increased for the apartment, we decided to move to Italy because activities of a private entrepreneur, I decided to terminate such activity, and there he had own residence, and that's why we decided to move to Italy.
And that was in 2000 and in August 2017. And that
Yes.
means that
Tak.
you lived here together with your husband in Kiev from 2013 to 2017.
Так.
Yes.
Your husband's activities, what did he live from? In financial activities or your husband?
My husband engages in trading activities, and he has done that for more than 20 years. Before that, before 2012, since 2003 till 2012, besides trading activities, he also had, together with a partner, a restaurant in Verona. His income from trading activities, as I've mentioned before that, is sufficient for daily life, to cover daily needs.
The trading activities, what is that? The trading activities, what is that?
He purchases and sells shares of different companies, but he doesn't engage into this professionally. That is, all these calculations occur only through the bank. If he wants to buy...
Very much. I'll go on. And you have been practicing law, and you have been a lawyer since 2008. And from 2014 to 2016, you were involved in a business about selling pasta, sale of pasta. Is that correct?
Since 2008, I received a certificate on the right to engage into legal practice, but I worked in the staff of different companies and organizations. Yes, really. In 2014, I registered myself as a private individual entrepreneur.
And in that, selling pasta was very fruitful for you because, according to official records, you got more than 400,000 guineas. Correct?
All data, I've provided the declarations, and all the data about income are indicated correctly, but take into consideration this time period that I spent, and that if you look into my declaration, you will see the income was not increasing. That is, when I registered myself in 2014 as a private entrepreneur, this was one income, and then it increased somewhat, and then it started decreasing. And take into consideration that my husband helped me in this respect, since it is clear that this is their culture, Italian pasta. He developed recipes, and he helped with manufacturing pasta, and he had less time to engage into his trading activities. Due to this, due to the fact that the income was not sufficient in relation to the expense of time and financial expenses that we had, we decided to terminate this status of private entrepreneurship.
And then you stopped your activity selling pasta, and then you started again in the field of law as a lawyer, and from 1st of July 2016 to 27 of April 2017, you acted as a lawyer. And in these 2 years, you have 0 income. Is that correct?
The matter is that when I registered private entrepreneurship on production of and sale of pasta, as we've indicated this, on 26th of February of 2014, I registered myself as a private entrepreneur, and since the 1st of July of 2016, I additionally introduced the Code of Economical Activities in the field of law, because I had hopes that if the business on the sale of Italian pasta was not going that well as we wanted it to go, I decided to introduce this code, to add this code of economical activities in the field of law with the thoughts about the future. However, I did not do that as a business, because people only started coming to me, as these were my acquaintances, friends, and relatives. And this was during that period when pasta fresca, this is the name of our pasta, it still existed at that time, and I needed to spend time on activities of a private entrepreneur.
I have heard a lot of pasta now, but now I'm coming to your activity as a lawyer. And I would like to hear a little about how many clients you have, and why these clients haven't paid you anything for those 2 years.
Because these clients that I had, as I've noted right now and as I've explained, they were other acquaintances or relatives, and due to this I decided that if when these were court cases, upon the end of court hearings or upon achieving a positive result, in such case, they would pay for my time that I spent on these cases, but it doesn't depend on me how much time court cases are last. And under these many cases, they are still ongoing, and they are still in court instances, or were in more specifically as of 2017. And still, in any case, if since August I was in another country, I couldn't dedicate such active attention to these cases. And due to this, my clients and I, we also took some decisions with postponement of payment when this moment comes, or when a positive decision with respect to them is taken. My husband agreed with this position. Our income, his income, was sufficient for that.
I can see that you have worked as a lawyer from 1st of July 2016 to end of April 2017. That 10 months. 10 months, and you say that you got nothing at all in these 10 months for your activity as a lawyer. Is you such a bad lawyer that you can't get paid, or can you give me an explanation on that?
Yes, but I've explained this fact that I do not think that I'm a bad lawyer. Maybe I'm not such an aggressively oriented for earning money. Yes, that is true, maybe. And these court cases, if they are not finished and if some relatives or acquaintances, friends, and I have come to these arrangements, I follow these arrangements. But I do not think that this is a sign that I am a bad lawyer.
6,000 US dollars. Is that stemming from Ukraine? As savings in cash, you have 6,000 US dollars. Is that coming from Ukraine?
Yes, these savings, these savings have been saved by me during my life. This is not for 1 year or 2 years or 3 years. And it also includes, I don't have an own car, apartment, or some valuable property. That's why I don't think that for a person, if I'm 35 right now, and if I've been working since 18, I don't think that the amount of $6,000, including the fact if there is some birthday, and my parents could give me 100, maximum $200. These are not that significant amounts that would be impossible for me to save, to accumulate since 18. And with respect to your question about cash, yes, once these funds were at bank accounts, but take into consideration the situation with banks that we had in our country and in general, Ukrainians, unfortunately, have little trust in banks. That's why, for me, it was more convenient to store this money in cash. Besides, if I currently live in another country, my mother is almost of the pensioner age, and my grandmother is also retired, and I worry about them. And if something happens, I want for them to have some money for solving their problems with health, which often happens at this age. Yes, Lorna Harris.
Can I ask you, please? Can I ask you, please?
Yes, of course.
You and your husband lived in Ukraine between 2013 and 2017. Is that correct?
Так.
Yes.
You have told us what your husband's income was during some of that time. Did he pay tax in Ukraine?
In Ukraine, he was here legally, based on the temporary residence permit. He had identification number.
I asked you a very simple question, yes or no. Did he pay tax in Ukraine on the earnings that you have told us about?
No, he did not pay taxes in Ukraine because trading activities was conducted by him as a citizen of Italy, and he did all that through banks of Italy. I have all these numbers.
Answers the question.
Yes, please, more questions?
On those earnings.
Так.
Yes, he paid all the taxes in Italy. And he paid all the taxes, and currently he pays the taxes as a resident, as citizens of Italy, because when he receives funds at his bank accounts, the bank is obliged to do that, and this is all done automatically. And all this is included and mentioned in the bank statements, and is also provided in the statement that of his that I have read before that. Luciuk Kozlova-Slenko. Diana Vladimirovna, I have several questions. You, as attorney, how were you taxed? I was I registered with the tax authorities only now in 2018. And how did you provide legal assistance without being registered as a taxpayer? How does it relate to integrity? I'm sorry, I haven't understood this question. This is a question to me, not to myself, but I will repeat it. How does it relate to integrity if you provided legal assistance and were not registered as a person providing such assistance with the tax authorities? Yes, with the tax authorities. The matter is that since 2008 till 2013, I worked as a staff lawyer. Till the end of 2011, applications on being registered with the tax authorities of a person who engages in independent professional activities, there was no such obligation. The matter is that I was registered in 2008, and this period when I provided legal assistance, I received no income from it. I'm not asking about income. You asked me why I didn't become registered with the tax authority. I was registered with the tax authorities in 2018 because when I terminated my private entrepreneurship, yes, I've received the answer, thank you. But please tell me, you provided legal assistance under criminal or civil cases? Under civil, commercial cases, not criminal. I had very few criminal cases. In order to represent as attorney, as you are saying this, we are not talking about payment. You had to provide an order, and in the order there shall be, one of the fields is number agreement and dated where did you take these orders and what you filled in there. What is the relation with registration with tax authorities? Yeah, we've moved from this to another question. I pay all attorneys' contributions. I'm registered in the Register of Attorneys, and Collegium of Attorneys of the Kyiv region provides me with these orders. I execute agreements on provision of legal assistance based on orders that I receive from the bar. And when were you registered as attorney? In 2008. And you have received orders since 2008? No, till 2013. Having the certificate on the right to engage in legal practice, but I worked in the staff as a lawyer. I was not engaged in individual practice. I'm asking you only about attorney's practice, legal practice. As a lawyer cannot represent interests under criminal cases. So I'm asking you about criminal cases. Where did you take orders? I received them from orders. I received orders, as far as I remember. I received them in 2016, maybe in 2015, from the bar of attorneys of Kyiv region. Diana Volodymyrivna, I would like to say you that in Kyiv region, the bar does not issue orders. The Council of Attorneys provides these orders, and this is a completely different body. Pavlo Sergeyevich, what is your question? I just want to learn from who issued orders to her. The answer has been provided. Yes, you say that you provided free of charge assistance to acquaintances, relatives, friends, but with the hope that they would cover expenses, right? Have I understood you correctly? I provided explanations about an income, and I said nothing about about expenses. When the PCAE members asked you about what did you live for, you said that I provided legal assistance free of charge with the hope that I would be returned. We had arrangements about expenses. Do you mean this or no? No. We were talking about income, about the reward of an attorney, about income as an attorney. And I said that based on arrangements with my clients, that I can receive income only after the end of the court consideration of the case, or depending on the essence of the matter, upon achieving a positive result for the client. And these decisions were taken by me in view of the circle of these clients. Thank you. Thank you. I've asked this question and I've received the answer. And what were the conditions? Didn't you agree before starting provision of this legal assistance, how this, or what were the conditions of these arrangements? That they should pay for a day, for a result, for an hour, for... I provided supplementary agreements to agreements that where it was indicated whether it was a percentage correlation depending on the amount of the claim, or whether it was a fixed amount depending on the question, on the issue. I cannot recollect it from my memory, but it is all present in the materials of my dossier. There are all these supplementary agreements that I've provided along with my application, and there we can see this, and we can see the text of these agreements there. But in general, their text was of the following nature: either in percents, depending on the amount of under the lawsuit, or funds that my client would receive from the debtor, or a fixed amount. Thank you. I have received the answer. Thank you. I have also another brief question. Please tell us, clients who were paid you no money, did they agree that you have the right for compensation of harm, and since you live in Italy, and expenses on transportation back and forth? Since the moment I started living in Italy, I didn't come for the specific purpose of court hearings. If I come to my parents, thank you, I received the answer. Thank you, Kozlov, please. Thank you, Mr. Chairman. Thank you, Pavlo Sergeyevich. Ms. Zanini, I have several questions with respect to the provided documents, with respect to the income of your husband. The first of these questions is the following. A tax resident of which country are you right now? I am a citizen of Ukraine. I am registered here, and I'm also registered in Italy. But with respect, not with respect to taxes, I belong to Ukraine. So for the most part of the year, you live in Ukraine. I mean about agreements on evading double taxation. Currently, it is not difficult. It is difficult for me right now to say. Not for the most part time of. For the most part time I live in Italy, except for this period of competition. Since currently I come more often here, I spent about 3 weeks in Italy and then a month here in Kyiv. But this situation is since August, and since August of 2017, I spent most of my time in Italy. The question is about documents that you've provided from the bank Fineco. Yes. Screenshots dated the 3rd of January of this year, if I correctly understand this word. This document reflects income, earnings, and losses from trading activities, right? Profitti perdite, right? The nature of this invoice under the securities, do you understand it clearly? Due to the fact that For this print screens, so that these print screens were clear, I provided written explanations from the words of my husband. Besides, I have also his written explanations signed by him, and I have bank statements. I will interrupt you. I'm sorry. I will repeat my question. Do you clearly understand what is indicated here? In these print screens, they are excerpts from his account. He has the account divided into the current and multi-currency accounts. These print screens show, at the end we see whether it was a plus or a minus, whether it was an income or a loss, and at what markets he was trading in. This is NICE and NASDAQ. There we see that. The matter is that here it is indicated. Stock market or abbreviation with which specific shares are indicated. This is the first line. The second line is the name of the company, of the issuer of these shares. The third line, not line, column, I'm sorry. The third column is really the name of the stock exchange, NASDAQ, New York Stock Exchange, and Amex. We also have in some lines. Then we have the quantity of shares and present in this account. Then we have the currency in which these shares are issued, and the last column is the income or the loss in terms of the stock value of these shares. What I'm talking about. The thing that you call income is in fact the currency difference in the share's value at the end of the specific period. And in order to receive this income, it is necessary to sell all the shares that are indicated here. So, of course, value of shares have increased or decreased. But do you consider to be net income? Right now, physically, because when we provided these print screens, this is what I could physically. I received a letter on January the 2nd. On January the 3rd, we made these print screens, and if we open in the first graph, there we will see the dossier of these shares. I have with my printouts in particular statements from his bank account that show all the funds that were transferred, and all the expenses are also evident there. If you want, I may provide them right now so that you could see them, look through them, completely look through the dossier of his account, his losses and his earnings. Of course, there will be losses, expenses for some daily needs. The amount of income in those documents that you are talking right now coincides with the difference of shares value. In this account, it is stated, the amount is stated. If we are talking about, for instance, for me to be, for convenience, yes, we would gladly look at these documents. Should I provide them right now? If I provide them right now, I will not be able to look at them and explain them. Please explain. We can make a copy. A lot of papers. But if it's the same we have on our laptops, we do not need it. But if this is really a statement on the movement of funds, this is another matter, completely another matter. We will look through them and we will give you back. This is for you, and this is also for you.
Concerned because we don't quite, sorry, we're concerned because we are not quite following what is being produced. If it is something new, then we need to consider the matter. If it's simply a better copy of all the screenshots, but I don't think it is. So we need to know why this wasn't produced before.
Yes, we want to look at these papers to find out whether it is something new or not. Just to look at it, whether this is the same or not. I can explain and provide the answer and comment. I'm sorry. Since we have an exchange of opinions, I inform that we are working for 50 minutes. How much time do we need? And Mr. Chairman, I ask for your opinion. How long should we continue?
Can I just deal with the documents? I understand that all you want to do is look at the documents to see whether they're new documents, but then I've got no objection. We have no more questions for this candidate. I think it's entirely in the hands of the Commission members as to how much longer this is going to go for.
Two questions. Vasilenko. While Kozlov is looking at these documents, then Vasilenko. I would like to go to another sphere. Please tell us. You said that you engaged with few criminal cases, and what about cases relating to corruption offenses? Have you dealt with such cases? No. No. Okay. In general, do you know the basics of legislation in the sphere of anti-corruption sphere? Taking into consideration that as of now I am at this special joint meeting, I passed testing, can you say just yes or no? We have no much time. I was evaluated by the Commission based on the practical assignment and theoretical task in this way. Please tell us, what is the difference between the competencies of the National Anti-Corruption Bureau and NACP? The simple question. Then NABU is a state investigative body. The NACP has other functions. Thank you. Thank you. Prelipko, yes, please. Please tell us, in Italy, under the legislation, Andrei Vladimirovich, please switch off your mic. In Italy, there are strong taxation and bodies. Did you attempt to receive from them certificates on your husband's income? Yes, and from them certificates if he has a bank account where... Yes or no? Did you receive certificates from them or not? From those bodies? For taxation, financial bodies, they have very strong bodies. If necessary, no. Right now, did you provide such documents or no? No. Thank you, because there was no such question. Thank you. Let's go back to Andrei Kozlov. Andrei Kozlov, the last question. Two last questions. In the document that you've just shown to us, it is indicated that, yes, really, your husband has about 103,000 euros as the capital, but it doesn't mean that this is income. How can you explain this, firstly? And secondly, while looking at these screenshots, we can see the section Certificazione Fiscale, that is online. Through the bank account, it is also possible to receive the bank statement. Didn't you try to use this service, for instance, just to receive the official document from the Financial Service of the Italian Republic? Yes. The question is that when I received questions and I was provided only with two days to provide my answers, I had an opportunity only to provide print screens. Then I asked my husband that I needed official bank documents in order to present them at the Commission and to confirm these print screens, because I understand that this is not a document. Then he turned by an email to the bank, and I will tell you that in Italy not everything is happening very quickly. Time is needed. At first, as I have provided the answer in the written form, in the written explanation, I stated that I needed about a month to provide all these documents in the paper format, to send a letter, to receive it. They are not in a hurry to perform their work there. And what I could do as soon as possible, this was done by me, because the bank sent to my husband these bank statements. You've seen them, and you see that these are official documents with the digital signatures of the bank. By the way, I have all of them in the digital format. And for instance, for 2016, here we have a breakdown by all the months. For 2017, 2018, only the end of the 15 we have. For 2016, 2017, not all sheets are present there. That is where it is. We can see the income, and we can understand these printouts and print screens. But if necessary, I have all of them at my email in the digital format. I can provide them, and I can send them. Thank you. Could you please tell us, do you know the amount of the fee that is deducted by the bank for provision of respective services under this securities account? Do you know the amount of the fee that is deducted by the bank for management of this securities account? No, I don't have this information. And the last question, have you paid attention to the fact that the number of shares and the number of companies who own these shares over these 3 years have changed? Yes, of course. And in such case, when there was 8,000 shares and there were 24,000 shares, was it necessary to spend some money to purchase them? The matter is that he has a multi-currency account, and some part is as the conto corrente at the current account. And then there is this multi-currency account where the funds are in dollars. If he purchases shares, he turns to the bank turns to the dealer buys these shares for the bank, and my husband buys these shares through the bank. That is, he has communication only with the bank. In such a case, the bank is a tax agent and pays all the expenses. Thank you. Diana Volodymyrovna, the last question. Anastasia Zaritska, and that's all. Yes, please. Please switch on the mic. I've looked through your motivation letter. It is not very standard, as you remember, but I would like to ask, in case you become a judge of the High Anti-Corruption Court in Ukraine, how do you expect to receive that adrenaline that you indicate in your motivation letter? The matter is that in my motivation letter, I'm not telling only about adrenaline. Yes, maybe I don't have a standard approach that should be with a smile here, even when all are serious here and I'm smiling here. But this is not, it doesn't mean that I'm not serious or that I'm not competent. I'm sorry, I'm staggering a bit. This is since childhood, and not because I'm telling some lies. Adrenaline, in any case, if you've asked about this one word, it is present even here, right now, when I'm sitting here. And as I wrote in my motivational letter, that I care about my country. And if I right now live in a comfortable way in Italy, and I agree, and I want to return here in order to make some small but my contribution, so that Ukrainians in those Italy. I've heard your answers, I've understood it, thank you. And I will ask you directly. Right now, as of now, do you think that you are ready to make all this that you've just mentioned? Yes. Thank you. Thank you. Diana Volodymyrna, thank you again for the provided answers. The interview is over. I have a motion about attaching these documents, all these documents. Mr. Chairman, may we satisfy this motion on the attachment of these documents? We have to decide this right now.
I'm being asked to answer the question. We say no, because it's new documents, and these documents could have been produced before. We have got 5 screenshots, and the 5 screenshots is not the same documents, are not the same documents as here. What we wanted, and have wanted all the time, is accountants for the whole earnings, the accountants which are sent to the Italian tax revenue, and a question about how much tax has her husband paid in Italy. That was what we wanted, and we got 5 screenshots, and now we got some documents showing the accounts in Italy, and I can't see that that would help anything in the direction what we want, and that was the accountants sent to the Italian tax revenue. So I think also from principal matters that we should say no thank you for these documents.
Thank you, Diana Volodymyrna. Your documents that you wanted to attach are not attached. May I comment, please? No. Thank you. Thank you. Please wait for the decision today. Ivasan Alexander Romanovich, please invite him into the room.
This is Ivasan Alexander Romanovich, the candidate for the position to the High Integration Court. We're welcoming you here. You are present at the special joint meeting of the High Qualification Commission of Judges and the Public Council of International Experts. You have the right to submit motions, to provide written or oral explanation, to provide your opinions. Objections on the considered issues, and also give recusals. Do you have recusals as of now? No, I don't. Thank you. There will be 5 minutes for the presentation of the PCE member. Within the next 5 minutes, you will have a possibility to provide your response and question and answers within 20 minutes. The presenter is Ted Zajechny, please.
Mr. Chairman, members of the Commission and members of the PCIE, this candidate, Mr. Ivasan, and the PCIE are both victims of the time limits with which we had to deal. We received information just before the PCIe referral meeting that raised a question about Mr. Ivasan's representation of 15 rather large agricultural corporations in a criminal case for which he was not paid. Unfortunately, time did not permit that question to be put to Mr. Ivasan. Subsequently, he provided a very full explanation, and we accept that explanation. So that matter is no longer of any concern to us. The only other remaining question, again, it arose very late with the receipt of some tax information with respect to Mr. Ivasan, and it is this, and I think that's all we need from you, Mr. Ivasan, is an explanation of that situation. Your other explanations are fully accepted. And that is that in 2017, you failed in your tax declaration, together with the declaration filed as part of your application here, to apparently declare your right of ownership of a Hyundai car, 50%, and your interest in the corporate capital of a law firm, both of which were reported in a decision that was taken with respect to your divorce case. Can you explain why your interest in the Hyundai was not declared, and your interest in the capital of the legal corporation were not declared in your 2017 declaration?
Будь ласка, Олександр Романович.
Please, Alexander Romanovich. With respect to this court case in Brovary City District Court, there was considered a civil case under my lawsuit to my ex-wife with respect to the division of the property of the married couple. The subject matter of this consideration was a car, a land plot, as well as corporate rights in the Attorneys Association. Subsequently, we repeatedly appealed with a peace agreement. We wanted to settle this dispute in a peaceful way, but unfortunately the court didn't consider it necessary to satisfy this request of ours. And under the arrangements between me and my ex-wife, the car had to be given to her fully into her ownership, and I had to receive the land plot. Subsequently, the court satisfied the lawsuit in part. He declared the half of ownership for the car as my right, and he denied in the majority of claims under the lawsuit. In the future, I and my ex-wife settled all our property issues in the following way. In May of 2018, my ex-wife, sold to me that land plot that I wanted to receive. In turn, I refused from the right of ownership for one half of a car. With respect to causes why in my declaration for 2017 I didn't indicate the right of ownership for the car, I explained that the right of ownership for the car emerges as of the moment of state registration. This is determined by the Civil Code of Ukraine as well as by the procedure of state registration of vehicles. After receiving the court decision, I didn't turn to state bodies of the Ministry of Internal Affairs, and such right was not registered by me. Besides, since 2015, since September, I have not been living together with my ex-wife, and I haven't used this car since then. And the right of use or right of ownership, I didn't have it. That is why I didn't declare this car, since I thought that from the perspective of the dispute that we settled together with my ex-wife, it would be incorrect to do that, since she sold to me this land plot and I gave to her half of my share. Since this car, as of now, is registered in my ex-wife's name, respectively, the need to re-register it in her name, I mean the right of ownership, my share of or right of ownership is not necessary, since I didn't register this half of the right of ownership previously. Yes, with respect to corporate rights, in September, together of 2015, I and other attorneys registered the Attorneys Association where I had corporate rights. And in this lawsuit, I had the claim on the division of property, but then I refused from these corporate rights, and there is respective information in the NABU's conclusion where they indicate no corporate rights registered in my name. And that is why, as of 2017, I had no corporate rights. Thank you. Please, questions? No questions? Lutsuk, yes, please. Alexander Mavanchi, I have one question to you. From among persons who recommend you, in clause 23 of the application, we have that it is necessary to indicate phone numbers there as well. There is one surname, Szczebolewski Valery Ivanovich, deputy head of the Department of Cyber Police. Please tell us, how did we have phone number here, but how did you meet each other, and how can he recommend you? What references he can provide to you? Maybe you were his attorney, I don't know that, but please tell us about that. I work in Kyiv National Trading University as a senior lecturer, and I have 0.25% of the workload. Cheboyevsky Vitaly Ivanovich is also a lecturer at the Faculty of Programming. Thank you, I've received my answer. And respectively, we communicate there. Dear colleagues, do you have any other questions? Yes, Shotka Stanislav. Please tell us, if we look at the documents of the NABU, you are a founder of, and as far as I understand, beneficiary owner of Attorneys Association, Case and Partners International, right? This is what its name. This is right. In 2015, the declaration that I submitted, and respectively, Alexander Ivanovich, yes or no? I'm not a beneficiary owner of this Attorneys Association, but you founded it, right? Yes. Is it functioning right now or not? Yes, it is functioning. Does it bring any income to you? No, it doesn't bring any income to me. And who receives income from it? I don't know. Unfortunately, I don't have this information. I can state that in 2017, it received no income. Please tell us. While providing explanations, you indicated that from LLC, with which you, as far as I understand, you had working relations, you received a salary from it, that under the court decision in 2011, you received 160,000 hryvnias, right? Yes. Was there some debt, or what was that? In 2010, I concluded the agreement as an individual private entrepreneur on provision of legal services to LLC. May I name it? Sokil. For provision of legal services. My task was to collect a huge amount, about 5 million hryvnias, and the agreement was that in case of positive decision under this case, I will receive 3% from the price of the lawsuit. It happened that I won this case, and during 3 months, but my client thought that it the case was solved very quickly, and he received this money very quickly. And he came to me with a reference that he thought that I had to work more in order to receive this 3%. Subsequently, I filed the lawsuit with the Commercial Court of Kiev, and the first instance denied in satisfying my lawsuit, and the Appeals Commercial Court of Kiev satisfied my lawsuit, and then this amount was collected in my favor. In your favor. Yes. Can you provide evidence of this decision execution? Together with explanations, with the first explanations that I also sent to the HQCJ, there is a receipt from the checkbook that I had as an individual private entrepreneur, and respectively in September of 2011 I withdraw the amount in the amount of 143,500 hryvnias. This is the amount that I received. Alexander Romanovich, did you understand my question or not? I was not asking about the amount that you withdrew from with the help of the checkbook. I asked whether there is evidence that this amount was under the court decision was paid to you and that you received it. Besides this evidence, I have no other evidence. Thank you for the answer. Have I understood you correctly that together with with LLC you had the agreement concluded in 2010? I rendered services to them since 2008, and under this court decision, if I'm not mistaken, yes, it was 2010. You provided services to them based on single agreements, or how did it happen? Most frequently, for each court case, I concluded a new agreement in order to clearly indicate all the conditions. Because I was acting as an individual private entrepreneur, it was easier for me to account these cases. What income did you receive from them during the period of 2008 to 2010? Do you remember? What amounts did you receive? Except for this amount, I think that about 120,000. Thank you. Please tell us. Based on the NABU's data, in 2008 you received from them 14,000 hryvnias. In 2009 you received 12,000 hryvnias. In 2010, 20,000 hryvnias. About 160,000. We have nothing information there. And you've just said that you've received from them. Remind this amount. About 120,000 or about 146,000. What figure are you talking about? For execution of the decision, I received it through the executive service. The executive service transferred this money to me. No, you said that while cooperating with them, you received in total, you named this figure. Then I made a mistake. Alexander Ivanovich, how much did you receive from Sokol for 3 years when you provided services to this LLC? Based on the calculation that you named, then no. What do you remember? We have the broadcasting. In any case, we can listen to your. I named the amount of 120,000, but I received all the funds from them as an individual private entrepreneur to the bank account. Why they, as a source of taxation, showed other amounts that you received from them? How can you explain this? Again, I'm telling you this. Then I made a mistake with respect to about the amount of 120,000. I was not reviewing the materials. Was the amount 160,000 hryvnias that you received from them taxed? Yes, of course, it was taxed. This 146,000 hryvnias under the court decision, I showed them in my reports in 2010, in 2011, and since, and respectively, all documents are present in the dossier about those amounts that I received. Thank you. In the written explanations, you say you are talking about 160,000. Now you are talking about 146,000. So, how can you explain this difference? In the explanations, if I open it right now, you can open it on page 4. There you have it indicated, I can quote, in August of 2011, I received from LLC Sokol funds in the amount of 146,000 hryvnias. So as of the end of that month, I received the total funds, including income in 2011, and there we have the amount indicated as 160,000. But from the Sokol, I received 146,000 from Sokol. So under the co-decision, how much did you receive? 146,222 hryvnias. And 160,000, what is that amount? In 2011, I received other income from other sources, and respectively, there was an amount of 160,000. Then I exchanged into dollars. Please tell us. Your wife, on July the 30th, of 2018, bought a house in Sely Ivankovича, Vasilkiv district. Yes. There was another co-owner, right? Yes. What is the area of this house? What is the area of the share purchased by your wife? My wife, upon my consent, I provided consent as her husband, purchased 1/2 of a house with the area amounted to 148.1 square meters of the total area, and the land plot was 549 square meters, that is 5.5 hundredths. And what was the price of this purchase? The price paid my wife amounted to 263,527 hryvnias, the equivalent of $11,750, a half of which was contributed by her, and I provided a half of this as well. And yes, you explained that you provided a half of this, but why the price is so low? How can it explain of this house? This is a garden cooperative. This is not the village of Ivankovича itself. Besides, the house was built in 1989, and it has no heating. It has no water. This is basically a premises where one can stay exclusively in summer. Besides, the previous owner was not using this property for about 12 years. And respectively, conditions corresponded to the price. The average price of such property was at this level, in this equivalent. That is $23,500 was the price of the entire house together with the land plot. Thank you. Do we have any other questions? Thank you, Alexander Romanovich. The interview with you is over. Later, a decision will be taken. Dear colleagues, may I announce a break for 5 minutes? Thank you. 5 minutes.
Навіть 10.
Even 10 minutes of a break.